What's up? Today is Saturday, May the 2nd is my daughter Luna's birthday, her ninth birthday. Everybody unmute and say happy birthday, Luna.
Happy birthday,
Happy
Luna.
Happy
birthday,
birthday,
Luna.
Luna.
Happy
Happy
birthday,
birthday.
Luna.
Luna.
Happy birthday, beautiful girl.
Love
My
you.
Taurus sister, my Taurus
Yeah,
sister.
I'm telling you, she's
Happy
turning 9
birthday.
today. We're gonna be celebrating tomorrow, so no worries. Yes, today is another Operation Wisedome.
Happy
We're gonna be going
birthday,
through
Luna.
Brett's. We're gonna be going through Brett's situation, but we'll probably be circling
My
around and
Taurus
doing
sister.
a lot more as well. One of the first things I wanted to cover today was that we just got a
My
brand new
Taurus.
dismissal. This is coming from Ricky down in San Antonio. Now, Ricky wasn't representing himself or presenting himself, should I say. But the fact still remains that Ricky did get a dismissal. And how Ricky puts it, he's down in San Antonio. So shout out to Texas, getting a dismissal down in Texas. And I find it very interesting on some of the things that he posted. Let me see if it's sharing. Is everything sharing? We all good? Y'all can see? Uh-oh. Let me pull this back over here. Here, back over here. Okay, so in Ricky's situation here, he wrote, "Hey, bro, I just got the good news that my case got dropped. I know I didn't represent myself the way you would have liked me to, but I did give that lawyer your playbook, and that's exactly what he ran with. Thank you so much, homie. The prosecutor threw it out. So kind of the same situation with Nina B over in Florida. Her situation was fruit of the poisonous tree. They opened up her car door. They found some drugs, 28 grams of drugs, and she presented what we had worked on together to the attorney. The attorney ran with it, and immediate dismissal. Same thing here applies with apparently Ricky. His situation was resisting of arrest, and San Antonio has closed the case. It's a complete dismissal. Got a bond as well, but I believe he can go right back to the bondsman since this is a dismissal. And oh no, if it's through the bondsman, I don't know. If he paid the bond up front, then he can get all that money back. But if you pay the bondsman, they're going to retain that. But on the 29th, as we can see, another dismissal. So we're getting dismissals all over the place. One more, I guess I will mention is who was that? That was Marcus. I think Marcus got another dismissal, not for himself, but for his family member. I think it was his son. Yeah, that's what he told me. He said his son got a dismissal. This one seemed like it was a little bit of a bigger case. Don't know exactly what happened, how it happened, or why it happened. I don't know the details. I didn't get the details from him. But we did get another dismissal. I don't know if I can zoom this one in. Maybe I can. Let me see. Oh, we can. Okay. So this one coming out of Florida again, Lake County. Looks like we had a robbery by sudden snatching. Not sure exactly again what's going on here, but it says a child, Marcus J. Sims Jr., and this is a nolo prosecution, right? So we got a nolo prosecute, another one, and again, these dismissals are coming through left and right by y'all standing on your God-given creator endowed rights, and I'm just so happy and thankful that all of y'all are doing such. And yeah, if y'all want to give a congratulations out to Ricky and Marcus for getting their dismissals, y'all can go ahead and do so now.
Congratulations.
Oh,
Good job.
Yeah.
Congrats.
Congratulations.
Yeah, great work.
Nice job. Nice job.
Yeah, we out here working, man. We out here getting these dismissals, and it's really good to see that people are standing up. They're trying to do as much as they can, even if they're not standing themselves within the pro se, persona sui juris. That at least they're moving things over to the attorney, and those attorneys are actually picking up exactly what we're bringing forth and getting it dismissed. And I think that's one of the biggest best things. It's pretty amazing to see. I'm pretty astonished that people are just forwarding things over to the attorney and the attorney's running with what we produce. So yeah. So I see that we already have Joe. I don't know, is Joe in here or no? Joe. Join, bro.
Usually
Oh,
we've heard from attorneys that they don't do that. It's
they
not
don't.
their specialty or whatever.
What do you mean?
They don't pick up our pleadings and practices and present them into the court. They're like, that's not part of my education or training
You know
or
what?
something like that.
What that has been predominantly the case in the situation as far as most of what we've seen coming from testimonies of others. Although we have seen, like I said, this is the second one now that I've seen where an attorney has picked up what someone has brought forth, presented it, and moved forward in such a manner and has received the dismissal. So we're doing
That's
something right,
awesome.
you know. Yeah, we're doing something
Yeah,
right if these lawyers are picking up
for
what we're
sure.
bringing. Another thing I want to mention to everybody is that Aaron or Seth and Andrea, if y'all haven't seen, got their situation up with the civil rights attorney, John, the
Yes.
civil rights attorney. So I haven't been able to watch it all the way through, but I do know if John, the civil rights attorney, picked up their video, then we know that it's case closed, right? John, the civil rights attorney, is not going to pick up any case and review it unless he knows that it's a violation of some sort. And since he picked it up, we can probably expect Seth and Andrea to get the win. Don't know how they'll pursue their civil lawsuit. I'm sure now that we have so many people probably recommending them to get an attorney, or attorneys actually picking up the situation and their video getting so big that they probably will get an attorney. But either way, it's really good to see that they're getting the attention that they deserve. I think a lot of us should deserve more attention, and I wish a lot of our cases would get picked up by more of the bigger channels to get the rounds. But it is what it is. We'll continue to do what we do, and at some point we'll continuously get the recognition, and I think we will. Shout out to my boy Brian over at High Impact Flicks. I had a conversation with him over the phone yesterday, I believe, and he's going to be covering at least Robin's video at this point on his caretaking welfare stop. He's covered Robert's video. He's covered quite a few other videos that we've done here within Wisedome in situations, and hopefully we'll see Robin's situation displayed soon to where we can get some attention on that. Today, what I wanted to do is focus somewhat on Brett's situation. He has a real sticky situation right now. He's been thrown into the speedy rights trial. He can't move his trial whatsoever. He has unanswered depositions, motions, and a lot of pleadings that are on the record that have just not been responded to properly. And I guess I wanted to give the floor over to Brett to kind of give an explanation of where he initially was at, and then kind of work through the court proceedings, and then currently where you're at now. Brett, go ahead and take the floor, brother.
Well,
And welcome. First off, nice to see you, Grand Rising.
Grand Rising. Yeah, well, I mean, I filed all my paperwork. We've been going back and forth to court since the beginning of January, and filed so many different documents, and they just kept denying everything. All my motions, they denied. They finally went ahead and the judge granted a motion to compel discovery so I can actually get a copy of the video footage, because they made me go down to Department of Assigned Counsel and watch it at their office. But due process, I got the rights to have a copy of it. So, and I went down there. The attorney, the prosecutor, they didn't have my video footage. So then I'm almost home, and the prosecutor calls me and she's like, "Oh, we can get you the footage. Can you come back?" And I'm like, "No, I'm almost home. Just email it to me." Then her assistant emails me an empty folder, and this is literally Friday before trial was going to be on Monday. So I went in there on Monday. I'm like, I couldn't even watch the video footage over the weekend. I got an empty folder in my email. So can we push this trial a couple weeks forward at least? And so the judge, they went ahead and pushed it forward to May 4th and 5th. And I had a readiness hearing on the 29th, on Wednesday. And Cam helped me, put together a bunch of different documents to file an emergency motion for a continuance of trial, readiness hearing, emergency motion to suppress evidence, and request for evidentiary hearing. Denied all that. Notice and demand for written findings of fact and conclusions of law. They just sent me that, so I actually got that in writing. I put that on my Discord channel. And also a renewed motion to dismiss for failure to respond to bill of particulars and affidavit. And also this emergency petition for writ of mandamus. I tried to go down to the Superior Court and file it with them, and they wouldn't take it. So I had to file it in the courtroom with the judge and the lady. I filed everything with her and told her, "Hey, give this to the Superior Court." But anyway, so the judge keeps telling me to get an attorney. So I actually did look into getting an attorney, and she's like, "You can't afford me." And I'm like, "Okay," but she really, really highly suggested I go ahead and get a public defense attorney. just because I don't have no experience, you know, represent myself in trial. Never done this shit before. So I did fill out the financial declaration form to try to get a public defense attorney. If we could try to, you know, give this public defense attorney the playbook on how we're going to go about this and beat these fucking charges. These motherfuckers are trying to railroad me, man. Just trying to straight railroad me.
So I had a discussion with Brett, and I think it was yesterday or the day before, probably on Wednesday or something like that. But could have been Thursday. But Brett was looking at the situation of saying, okay, I've never gone through a trial before like this. I'm looking at maybe possibly wanting to hire or get a public defender to run through this trial one time, see what's going down, see what they're doing versus what I'm doing. And I kind of want to be like, okay, yeah, but at the same time, I want to be able to support my boy all the way to feel, have him as confident as he can be. But again, it's all dependent upon how one feels, right? If one doesn't feel confident enough to do so, by all means, do what you got to do. But one of the things I wanted to show that Brett did file was an affidavit, right? The affidavit, I don't think, has the affidavit been responded to by the state in any form or fashion? Right.
Yeah. Well, I mean, I think they gave me like they responded to pretty much everything I filed, but they just give me a bunch of BS answers, and they didn't really respond like they should have. That's for sure.
Okay, and so in relation to a response, what responses all did they give you thus far?
Well, shit, I would have to look into my email. But I don't have I don't think I have any of their responses in my channel. I just got everything pretty much that I filed. I did just put what I filed, what the conclusions of law and written findings. I just added that this morning. So, because we demanded that, but.
Let's check out a couple of these things that I uploaded here. Maybe we do have a response.
But I think you got a bunch of their responses, and that's what we based the new filings of mine off of. You know what I mean? Okay,
yeah. So we have a state's response for the bill of particulars. Let's check what else out. We got that one. State's 4.7. State's notice of discovery, anticipated witness testimony, and written demand for discovery and information pursuant to. Okay, so we got that one. Let's see what else we got going on here. I wonder if they responded to your affidavit. Now we got that one. Let's see, we got district court. This is state's notice of discovery. Anticipated breath alcohol content will testify to his or her training. Breath tests.
Yeah, all they have is officers right below that, officers observations right there at the bottom. All observations relating to the incident. That's all they have as far as them trying to fucking give me a DUI. Fuckers.
So no blood test? Yep.
Nothing. No, they just I didn't get my ID, and they just fucking broke my window and ripped me out of my car and slammed me on the ground. They're trying to say that I was trying to hold my steering wheel with my leg, and that's why I was obstructing when they were, undid my seatbelt and drugged me out of my car, dude. And okay, I didn't try. I'm 6'7" in a little Toyota Echo. I didn't purposely try to stop them from dragging me out my car. So there's no obstructing.
And my boy is bullshit. So you got your demand for bill of particulars, 6 pages. Regarding the nature and cause, state with specificity, identify the legal name. If there's no injured party, state the specificity of the legal basis upon which a crime can be alleged to have occurred. State the specificity of each and every element of each offense. Prove a trial for each element identified in response to particular force. State with specificity the evidence. State with specificity the mens rea, the mental state required for each alleged. State with specificity the actus reus. Traffic violation with gates. Not for hire. Yeah, so we're going pretty deep on the bill of particulars. Let's see what the response is. You should present an answer. No. The court should deny the defendant's request for a bill of particulars. So whether a bill of particulars is granted is a matter of left to the discretion of the trial court. The request should be granted if it is necessary that the defendant have the particulars sought in order to prepare his defense and in order that prejudicial surprise will be avoided. No bill of particulars is required if the particulars are already in the charging instrument or if the government has provided the information called in some form of satisfactory form. The test in passing on a motion for bill of particulars should be whether it is necessary that the defendant have the particulars sought in order to prepare his defense and in order that the prejudicial surprise will be avoided. The defendant should be given enough information about the offense charged so that he may be used with diligence, prepared, and adequately for trial. If the needed information is in the indictment or information, then no bill of particulars is required. Same result is reached when the government has provided the information called for in some other satisfactory form. A recent unpublished opinion. The defendant challenged the trial court's denial of the bill of particulars. The defendant argued that the information failed to provide complete notice of the essential elements of the offense's underlying facts. The information that was in January 2026, State versus Johnson. Interesting. Washington appeal to. The court on appeal determined the defendant was not entitled to bill of particulars because the information sought was available to Johnson in the charging instrument and through the discovery process. The information provided dates, ranges. Okay, good. Similarly, State versus Dictato, the defendant requested a bill of particulars and claimed lack of notice and vagueness for the charges of the information was overruled. The court determined that technically a proper information may be subject to a timely motion for a more definite statement, which is pretty much the same thing. A bill of particulars is a motion for more definite statements. They're about the same. In some states, they allow for a bill of particulars. In other states, they want you to title it as motion for more definite statements if it is vague as to the specifics of the crime committed, but nothing in the record indicates that the information beyond that already provided the state could have furnished and given the additional notes. Here, the bill of particulars is unnecessary. Okay, first valid charging instrument was filed. This included information, affidavit, determination for probable cause. Continues to comply with 4.7 to disclose all information in its possession. Let's see. Finally, been read his rights at the hearing. So, in your bill of particulars, you brought forth use of force, termination of the tire deflation device. You started asking real specifics, and they didn't answer to all of the specifics. Did we give a response back to that?
Oh yeah.
Okay, we did. So then we filed the bill of particulars reply. And was the bill of particulars reply denied as well?
Oh yeah. Everything was denied except for the motion to compel discovery to give me a copy of the video footage. Everything else has been denied. Everything.
Oh, okay. So then after we got back the state's response, we filled in a reply. The defendant's reply to state's response on motion for bill of particulars, renewed motion to compel, a motion for sanctions, and a memorandum of points of authorities with a special appearance. Introduction, the state's response is deficient for the following independent and compounding reasons, each of which will be addressed in full hearing. First, the state has fundamentally and irremediably misapprehended the constitutional nature of the bill of particulars, conflating it with an ordinary discovery, thereby stripping it of its constitutional force. The reply is supported by the defendant's previously filed affidavit of truth, notice, and demand to dismiss as unconstitutionally applied, and all exhibits attached thereto, each of which is incorporated herein by reference in its entirety. Brett, I know you got one of the first hearings where you went. Do you have the motions hearing audio or no?
Yeah, I got all the audio on every single time I went into court. I was recording.
Okay, where's your motions hearing audio? Did you send it to me in this last batch?
Which hearing is it you're talking?
Your motions hearing.
For on February 5th, or was that the March 18th hearing?
Whichever one was where you was going over your motion to dismiss and everything like that.
Oh, I think I did send that to you, and we went over that before we okay,
so I got
developed the next thing to file.
This one is empty. Let me make sure I hit.
Oh, well, that is what I just recently sent you, the audio
okay,
of the hearing just the other day, Wednesday's hearing.
Okay, so do you think you have the audio from the motions hearing? These are both PDFs.
Yeah.
Yeah, I don't have them in here, Papa. In the one email, let me check my other email.
Now, what day was that?
I'm not sure when your motions hearing was. That's what I'm asking.
Oh, I'm thinking it was the March 18th.
These were both January's, and then I'll search over here too. I don't have the audio from your motions hearing.
Okay, I know you got the audio from the February 5th one, but not the 18th, March 18th. I don't think.
Yeah, try and see if you can send me that one real quick.
Okay.
Photos. What's in this photos? Oh, okay. Let's check this out.
That's like a 41-minute clip.
Oh, load it.
Okay, I just sent it to you.
Okay. Getting this other one loaded up.
This is the state of Washington versus Brett Raymond Gollett, cause numbers 5AC0036163 and 5AC0036162. DPA Alex Strike for the state of Washington. The defendant is present out of custody and is currently representing himself in this matter. These matters before the court this morning for a trial readiness hearing.
Oh, this is from
yes, Your Honor,
on Wednesday.
be declaring ready at this time.
All right, Mr. Gollett.
Okay. Let's see.
That's when I filed everything, and then they had to take a recess, and then we came back and we went over everything for about 23 minutes. That second audio would be what we went over after I filed everything that I filed at the beginning. Now that what I just sent you now, that's March 18th's motions hearing. That's like a 40-minute clip.
All right, let's get into it. No, that's
Yeah.
good.
I think like the first, I don't know, 8-9 minutes, or I don't know, is just going over me, represent myself, and not having to fill all that shit out. So we didn't get into nothing really till probably 10 minutes in, maybe. Yeah.
I might not be able.
Yeah, I did. I just can't afford it. So I'm just going to continue to represent myself.
And you do understand that you can't afford it when you get
Yeah. Public defenders, they work for the state. I'd rather just represent myself, please.
So I have before me a notice of waiver of right to an attorney. So you're aware that some of these are gross misdemeanors with a maximum sentence of 364 days in jail, $5,000 fine, and has the right to an
Can y'all hear it?
Barely.
Let me see if I can. Download. Come on, download from me. Give me 1 second. Try and download it. Jeez, everything's come on, download. Must be a big one. I'm gonna try and open it up in VLC, then I know I can boost up the volume heavily. Jeez, it don't really download. It's crazy. Come on. Jeez. Refresh. Download this one. Download. Shift. Download. It's not letting me download it. There's Joe. Man, it's not letting me download it. It just keeps on spinning. Make those captions.
Thank you.
And I think you're working off your computer mic and not your other mic. Catching a lot of background.
Okay, so Mr. Golick, I have before me your motion that you filed on Friday,
Better now.
March 13th. Basically, you're asking for certain things of the prosecutor. The prosecutor's under the belief that they fully complied with their discovery obligations. And so I don't think I need you to add anything here. I know it did talk about, I think I kind of need to go one by one over the things that you're requesting in addition to everything they've already given you. Okay, so that's how I'm going to handle this. Is that okay with you?
Okay.
Okay. So the first one.
Let's see what you got. This is good to have.
I do want to address the audio and video. The state had indicated on Friday that they had complied with that and had provided a copy of the evidence and counsel for reviewing, that you had viewed that. Your objection with this is that you would like a personal copy that you can, rather than having to sit there to review it, that you can actually take home.
Right.
And so I was giving that some thought. They have complied with their discovery obligations, and it actually complies with the protective order that went into place. And I saw it here now. I'm having a hard time finding it. There's some very when it comes to a protective order as it relates to discovery, the court has discretion.
Audio is really bad.
So they actually signed a protective order that limited your ability where you can view this. So if you were at the jail, you could review it on like a jail laptop, but you couldn't do any internet searches or anything like that. All you could do is
To the point of almost an audio can't hear it.
Unaudible. Yeah.
And I'm treating him as an attorney in court. What is the state's basis for asking him if he doesn't receive a copy of
I'm gonna go somewhere else.
other than the discretionary decision made by pro tem and he signs that protective order?
Correct, Your Honor. In my brief, I did mention that it was discretionary and it was signed, I believe, on February 12th by Pro Tem Uribe. I was able to go to speak to a supervisor about this matter.
Can anybody else understand what's going on? Because this is totally unaudible to me.
It's inaudible for you. Is it inaudible for everybody?
Yeah, for the
No,
most part.
I can understand it. Read it.
But the reading's good. Yeah,
Be
you can read
quiet.
it pretty good.
Pretty low. You got to read it.
No.
So I'm trying
Flip
to
the
download it and
phone.
it won't download. That's my problem right now. Look, it just keeps spinning. So every time I'm trying to download it, it don't want to download it. Because if I could download it, then I could just boost it up in VLC real quick. But it won't download all. Preparing download.
I can hear you just fine. I got my speakers turned down.
I mean, it was a little low, but that's why I kept trying to download it. It won't download. See, it just keeps spinning.
Hey, Cam, that's the one where, you know, I did the motion to compel Discovery to get the video, the copy of the video. That was literally right before we were going to have the first trial.
There it goes. There it goes. There it goes.
So I think you want to listen to the one where they just denied my bill of particulars and all that shit. I think that was like around the February 5th one, I think.
Well, where is that one at? Because I got this one you just sent me, which I think is still good because I want to hear what the judge got to say in relation to what she's got, and then in correlation with the new document, which is her findings of facts, right, and conclusions
Yeah.
that she sent you. Because I've already thrown that in, and we've gotten, you know, your whole emergency situation and analysis, which we'll go over as far as process is concerned. But I wanted to just give everybody the background so we know exactly kind of what's going on. And I've never heard this hearing before, so I do want to hear.
Yeah, you never heard that one, yeah.
I've never heard this one at all. So we're about 2 minutes out. Okay, so let me see these others. YouTube.com. And just briefly, I guess, show the situation on what happened with you as this is downloading videos and WSC RSP, Casey Smith.
Right to travel gone wrong. There I am. Right
Where's
there on
that?
the right.
Oh yeah, Deputy Gates is back.
Can't believe this shit.
Second time.
Full name and date of birth, or an ID card,
I surrendered my driver's license.
or you can just give me your name and date of birth.
Okay, are you going to take me to jail?
If you don't give me that stuff, yeah.
Really?
Yep.
And all I want to do is fucking just...
Go.
What's this guy doing?
It's just something that we do.
Precautions. I'll shut this fucking thing off. It's a big deal.
I totally appreciate that.
Like, look, all I'm trying to do is exercise my rights, guys.
Right. I totally get it. Not mad at you at all, right?
Let me put this in because
What's his name? Is he
you
giving a
don't
name?
know my name.
Hey,
because I haven't
Oh, but they
committed a
violate
crime.
you under color.
Report it. I am going to break your window if you do not give us your identification.
Here we go. Guys, I have done nothing wrong.
Okay. Told you what road we're going down, man.
All right, you have 10 seconds.
Wait,
10,
let me
9,
talk.
Listen to him.
7, 6, 5,
Wait,
4,
whoa.
3,
Open the door.
2,
Wait,
one.
you gotta get you in the door.
Get out of the car. You're under arrest. You're under arrest. Get out of the car.
For what?
Unbuckle yourself. Get out of the car.
For what?
Get out of the car. Get out of the car.
Okay.
Get out of the car.
Goddamn.
Get out of the car.
Motherfuckers.
Under arrest. Get out of the car.
Hold on, I'm not.
Get out of the car.
Why are you guys doing this to me?
I got knife. Pull over.
You didn't give us your name, so you deserve to get beat up.
Oh, dude, I had
You
a
didn't
big
waive your
ass,
Fourth
I had a
Amendment right to
big
be
bruise
secure in
on
your
my
person,
arm
person,
for like a
Oh,
month.
sorry, Brett.
All right, y'all both spoke. What now?
Oh, I'm
He
just
didn't give
saying I
up.
had a big ass bruise on my arm for almost a month.
He didn't give up his Fourth Amendment right to be secure in his person, papers, and property.
The court has
Prevent
discretion.
any
Brett,
searches.
you told him to hold on, and he didn't even stop counting. He didn't even pause or anything like that. He just continued to blast right through that and then smash the window.
Right.
No
You
DS.
didn't incriminate yourself either. That's why.
No, I wouldn't give my ID. So I hadn't committed a crime.
I wouldn't give him shit either. Go ahead and violate me.
Actually signed a
I'm not giving you permission, but you're gonna do what you're gonna do, and I'm gonna do what I'm gonna do.
I would have hollered, my arm hurts, take me to the hospital.
where you can view this.
Yeah,
So if you were
his vehicle was turned off. The keys were on the dash, and he was in. I mean, he could have fled in the vehicle. That's what the why they could have ripped him out of the car, because he could have fled in a turned off vehicle.
No,
And there was no fear to the officer or immediate danger.
No, all I want to do is I just put my key back in the ignition, so I had my body cam still, or my video dash cam still working. That's all. They already put a fucking tire deflation device around my tire. I was never gonna flee. Fuck no.
No, what I mean is you turned off the vehicle, right?
Oh, but yeah, it had been off the whole time. I just had it on the, the first notch up, so my power would be on inside for my dash cam to be on. That's all.
Accessory mode.
Yeah.
By having your vehicle turned off. Well, the whole reason that the vehicle exception of the Fourth Amendment clause violation, the 1920 whatever ruling, the Supreme Court says the vehicle exception of the Fourth Amendment, they can do the vehicle Fourth Amendment violation is because they can.
Well, it's because they got plenary power.
No, it's because it can flee. It's a mobile device that you can get away quickly in. But by turning it off, you take that away from the equations. And by them putting that device under your tires to prohibit your fleeing, they excluded that fleeing from the equation. So your fleeing capacity was taken away. So they had no real reason to take you out of the vehicle with violence, I yield.
Yeah, I had my car off the whole time. I just wanted my dash cam on. So
you could review it on, I think it said their jail laptop, but you couldn't do any internet searches or anything like that. All you could do is view it. You can alter it.
Mm-hmm.
And if you're out of
custody, their whole thing was
then,
excessive
you could
force.
review it at Department of Assigned Counsel. I understand that was discretionary, but here's my problem, and I guess I want to hear from the state. If he's representing himself, and I'm treating him as an attorney in court, what is the state's basis for asking only review that he doesn't receive a copy of it and only reviews it at Department of Assigned?
Right.
And the discretionary decision made by Pro Tem Uribe when he signed that protective order.
Correct, Your Honor. In my brief, I did mention that it was discretionary and it was signed, I believe, on February 12th by Pro Tem Uribe. I was able to go to speak to a supervisor about this matter, about some of my own concerns about this. And what our proposal would be to the court is that since the Department of Assigned Counsel already has the flash drive of media for Mr. Golick, that he brings his own flash drive to the Department of Assigned Counsel. And he's able to retrieve the media from them.
So they initially tried to tell you couldn't get it, and then now you've gone into the court to say, I do want it, and then the judge is literally like, well, if he's representing himself and we're treating him as an attorney, why can't he get the information? And so then they're like, oh, well, I guess he can. He just needs to bring his own drive, right?
Yeah, and I went to Department of Assigned Counsel on Friday before my trial was supposed to be on Monday and Tuesday, and Department of Assigned Counsel they had no clue. They didn't give me no copy, no nothing. And I called the prosecutor right away when I was leaving there, and she didn't answer. I emailed her, and then she calls me back when I'm almost home, and I'm like, no, I can't. I'm almost home now. I'm 40 minutes away, so just email me the footage, please. And then her fucking assistant emails me an empty folder. So I couldn't even watch the video footage at home over the weekend before my trial on Monday. So I went in there and I'm like, hey, I need at least a couple more weeks. They emailed me an empty folder.
Okay, hold on. We'll get there. We'll get there.
Okay, that sounds appropriate because after I was like looking into this, I was feeling like, he should have a copy of that. You shouldn't be restricted.
So the judge is sitting there saying he should have a copy of it. He shouldn't be restricted. He shouldn't have to go in and just view the documents according to y'all's schedule at y'all's facility. This is what I think a lot of people have problems with is when they try to go get their discovery, right? The state is coming through and saying, oh, well, I mean, I just posted it recently with another Wisedomian. Yeah, we don't have to give it to you. You can come view it when you want. But no, in all actuality, when you are pro se and you are treated as an attorney, you have the right to have all discovery in your possession, to be able to thoroughly go through it and review it at any point in time, to where if you want to stay up till 4 a.m. to develop your theory and your defenses, you can, because you have possession of it.
And then that's why I started reviewing, and the court does have discretion. I could put that protection order in place. I didn't do it, somebody else did, but that was at arraignment. That was very early on, and I believe in the process, I'm not sure. I was just kind of going through your case file. So I think that's
and don't prove
if you
it.
have a flash drive, you can go over to the Department of Assigned Counsel, they have it, and they can make a copy for you.
I'd have to go buy one, I guess. Okay, thank you.
So that will be the court's ruling. My other, is there any concerns on behalf of the state about use of this video, about once it's in his possession?
That was something that was discussed with Supervisor, Your Honor, but after looking at some of the case law, it just really seems like there should be some way to provide it to him, especially given that there is no victim or anything in this case that we would want to redact them. So that.
Oh, no victim, no corpus delicti, no verified complainant, just admitted by the state.
That ultimately was the decision.
Yeah, you were the victim, Brett. You're right.
Brett's victim.
Yeah, Brett was the victim.
About posting on the internet, or prior to the trial date, using that in a way that an attorney wouldn't use it. An attorney wouldn't go on YouTube or any social media and post this when we have a pending trial date. I mean, that could potentially cause trial issues in the future. That's all I'm thinking.
Yes, Your Honor. And if the court were to impose any restrictions on that, I believe that might be appropriate. That Mr. Golick only use it in the sense that he is representing himself as his own attorney.
Okay, does that make sense?
Yeah, I'll just keep it for myself so I can review every single video. I didn't have time to review everything there. I only had a 2-hour window.
Okay, well, I think this is fair. So that's going to be the court's ruling in order.
Okay.
All right, so that's that. Okay, about failing to disclose material exculpatory impeachment evidence, they provided you everything that they have in their possession. I don't know what this means. It says an erroneous NCIC one-person hit. What is that?
Oh, in the CAD report, somehow there was some, I don't know, Spanish person in the CAD report, some sexual offender or something. I don't know why that came up. It's not me, that's for sure.
So this is how you're proceeding at a disadvantage. I'm just trying to tell you, you're a very intelligent man, and I'm not putting down your intelligence. It's just being trained in the legal field, and you know that takes 3 years.
Yeah, I comprehend.
Training, yeah. And so. Does the state know what he's referring to? I wasn't.
I did look into this matter briefly, Your Honor. It looks like there might have been something input wrong where someone else's information came up, and there was a different NCIC. Maybe the state doesn't even have this NCIC, Your Honor, for this erroneous person. Nor was this NCIC used in any way in the decisions that were made with Mr. Golick in terms of using force or pulling him over. So the state's position would be that it's irrelevant to this matter, Your Honor.
Well, and I see how he's thinking it's relevant because the use of force element, and you were thinking that maybe it was based on that. But see, that's why if you had an attorney would interview all the officers, get to the bottom of some of these things, whatever they could use, they would use it during the course of trial if it was relevant, but they would know how to look at this case. And I get you have this idea, well, I mean, that, you know, if they work for the state, therefore they're not going to be working for me in my best interest. They're under an ethical obligation to do so. And as I mentioned before, the defenders that I have in my court are very experienced attorneys. They've been to trial. I've seen them in trial. They can't just sit there and do nothing. They have to represent you.
Yeah.
And so, you know, I keep hearing these little things that are going on that you're not going to know what to do with because you don't have the legal training. And so let's just say hypothetically you brought something like that up, because I see what you're thinking, and it was in your writing, and that, you know, maybe this is what caused things to escalate so quickly because they thought I was someone else kind of response. You're in a trial setting, you start asking officers these questions, there's objections. I can't help you out. I'm going to be sustaining objections if it's not relevant to what's going on. And so just once again trying to talk you into getting some form of representation, because I know that's in your best interest here.
Yeah, I've been doing a lot of research. I feel like I can represent myself.
Anything unless you know how to analyze it.
Yeah, I know how to analyze everything.
Well, some of these things make me think not.
Okay. Yeah.
Okay, so that's that.
Can I go over this motion that I filed?
No, I'm going over it because I don't need you to state anything. I'm just going to go over it and I'll allow both of you to talk and then make my.
Okay, thank you.
Good. Okay, so then it talks about the use of force policy with the Sheriff's Department. I'm first going to talk to the state about that. I don't know, you know, if that is in your, if you have the ability to get that information.
I don't have access to it, Your Honor. I'm sure there's some way I could, you know, reach out to a supervisor to contact the Sheriff's Department and obtain it in some way. However, I think that largely their policy doesn't have anything to do with whether or not he was resisting arrest.
Well, right, but there's also situations where it is lawful to resist. And because, you know,
on the record,
can use force to resist. This is just according to the WIPICs. If the person arrested is in actual and imminent danger of serious injury from the officer's use of excessive force, the person may employ such force and means as a reasonably prudent person would use under the same or similar circumstances. And then it's the state that has the burden of proving that the force used by the defendant was not lawful. And so this is WIPIC 170201. So I think there's some, I mean, I think it can be hard to say serious injury, imminent danger of serious injury. I mean, I don't know. I don't know the facts of the case very well. I'm just looking at what the state should be producing to the defendant. And so I think it might come into play. I think it's relevant.
And Your Honor, I actually have a little bit of additional information on this. Just a brief Google search shows the Pierce County website has the Pierce County Sheriff's Department like use of force disclaimer and information on it.
Okay.
So it looks like it's publicly available for Mr. Golick.
All right, did you hear that?
I heard it,
Okay.
yeah.
So, you know, if they don't have it directly in their possession or ability to get it, if it's something you can get, then it's, she just did a quick Google search and found it.
Okay, yeah, I'll look into it.
Okay, so that takes care of that. I don't even know what you're talking about when you say the surety bonds of arresting officers. I don't know what that means.
Okay.
Do you want to explain that?
Yeah, just the surety bonds that they're, you know, operating under.
I don't know what that means. I don't think it's relevant.
Okay.
Okay. And then the disciplinary and personnel records of the 6 testifying officers, you're not entitled to that. They provided everything that was exculpatory or maybe a potential Brady violation. I think Ms. Gregg wanted to say something.
Yes, Your Honor, thank you. I did a search before I sent in my motion of all potentially impeachable material we have on these officers, and there was nothing from any of these officers as of the date that I filed my motion.
Yeah, so that is what they're obligated to turn over. And so just based on what she said, I don't think there is anything.
Okay.
Okay. Do you want to add anything?
No, I just wanted to go over the couple of motions that I filed last Monday. You said you were going to hear me on those.
Okay, like one at a time. We're doing the motion to compel.
Yeah.
Let's finish this.
Okay.
Yeah, this is a motions hearing for sure.
Fail to acknowledge exculpatory significance of its own records.
Yeah, they're going through your shit right now. Motion to compel.
We've already discussed the pretext stop, so you're talking about the CAD report and the fact that it stated fake plate on there. And so you're going back to the pretextual stop argument. I've already made my ruling on that. We already discussed the view only restrictions on the audio video. As for the complete unredacted CAD report, they have the right to redact if there's other witnesses or any other private information. Ms. Gregg, was it? I don't know what the CAD report looked like.
I can take a look at that, Your Honor. I'm not even sure if the state had any redactions on the CAD report that we gave to Mr. Golick.
A lot of times, like if there's Mr. Golick, like a 911 caller that calls in with a name and a phone number, they don't want, you know, the accused to be able to harass these witnesses or contact them, that sort of thing. So that's usually the basis for redactions, or if there's like any minors involved, they'll redact the name, date of birth, that sort of thing.
Okay.
And just a brief look at the CAD log, it looks like we didn't redact anything on it.
Okay.
It looks like anything that we would redact is basically just Mr. Golick's own information.
Okay. They've already gave you all audio recordings, communications between the officers during the stop. What do you mean by that, Mr. Golick?
The communications.
Communications between officers during the stop.
Oh, I guess just like whatever audio they were, you know, speaking amongst themselves. Yeah.
Radio?
Yeah, I guess.
I don't know. I think they've given you everything. I'm assuming. I guess I'll ask this.
That's correct, Your Honor. We don't have any sort of radio calls or texts or transmissions. And I don't believe there were any 911 calls on these cases, but even if there was one, which I don't believe there was, it would be past retention at this point and would not be able to be retrieved.
Okay. So that you've been given every audio video communication that they have.
Okay, thank you.
And then the tow report and inventory of the defendant's vehicle. That should be within the prosecutor's possession or ability to get it. I've seen them before. You'd be entitled to it.
Looks like looking at the authorization to tow impound right now, I believe that should have been given in the evidence to Mr. Golick. Okay. If Your Honor, if you want, I can show him briefly and confirm that he has it.
It looks like it's part of your discovery packet, and so she's going to show you what it looks like.
Okay, yeah, I think I've seen that.
Okay. Chain of custody for any seized items?
I don't believe anything was seized, Your Honor.
No, they didn't seize anything.
Okay.
They left my keys in my ignition and left my phone in my car, and I told them, please grab my stuff, and they didn't grab it. They asked me if they wanted to grab it for me, and I said, yes, please.
Yeah.
And then they just left my ignition, my keys in my ignition, left my phone in my car.
Well, you have a copy of the impound.
Yeah, I know.
All right.
Yeah.
Any prior complaints against the officers, they've done a search, they've turned over anything that would be potentially impeachable. And so, yeah, that goes to exculpatory impeachment evidence in their possession and control. They've given you all of that. Okay. So they have not violated their discovery obligations. We fixed the ones that need fixing as far as being able to get a copy. They have complied with their Brady obligations. We've already talked about the pretext stop. I ruled on that on Friday. There's some information on that erroneous NCIC hit on a document. If that's something that you're just going to have to know what to do with and how to address it, and if it's relevant or not. I mean, I don't know. That's why I get involved.
All right, what she's saying right here is you're going to have to figure out how to deal with that. What she's saying is motion in limine. That's what she's saying right there. She can't tell you. You got to bring forth the motion in limine, but essentially that's what she's saying. You're going to have to deal with that. She's saying with this NCIC hit on somebody else, you're going to have to figure out how to deal with that. She's saying motion in limine to exclude any hearsay evidence that is out of a court statement, which would be within this CAD report that doesn't, that is not you. You got to exclude that.
Interviews and
that's what she was saying.
Knowing what to do with information and whether it's relevant or not relevant. Why go down a rabbit hole if the court's going to rule it's not relevant? Also goes towards like motions in limine, which
there she goes. She said it.
And so the state will probably bring up.
Which she's giving you legal advice, which is kind of crazy, but yeah.
A whole host of motions to kind of excluding some of these things that you've raised here that they're going to argue that are not relevant. You're going to have to argue as to how. We talked about the use of force policy. The state has willfully violated its legal obligation by failing to disclose impeachment evidence. We've already discussed that. State's discovery violations constitute governmental misconduct. I'm not making a finding of any discovery violations at this point. Now, if something should pop up in the course of trial, it sometimes happens, then it needs to be addressed. But the state's view only, we already discussed the view only policy. The body camera footage must be produced in a standard accessible digital. Yeah, we've already discussed that. Okay, I think we've covered everything here. No sanctions involved because I didn't find a discovery violation. And then I see your request for continuance. Okay. That covers the brief that was filed on March 13th. Now you wanted me to go back and discuss the ones that were filed. We reviewed those on Monday. I'm going to let you tell me what those are. I'm pulling them up. They're from March 9th, correct?
Yeah, the motion and the.
Now she did go through your prayer for relief, but she failed to. She said, "I see you wanting a granting of a continuance," but she didn't say anything in relation to scheduling an evidentiary hearing.
Right.
She straight skipped over that.
Yeah. Memorandum. On Wednesday, she
so
just
here, what I'm pulling up is
grant me any evidentiary hearing whatsoever.
Oh
no, I filed another motion also.
You need to tell me what's your motion entitled? What's the motion about?
Just, well, I don't even have it with me right now. I know I filed it though. I don't have it with me, so.
Okay, well.
And the memorandum for the
supplemental memorandum, and it's all things. And here's the title: Claimant Defendant Supplemental Memorandum of Law in Support of Notice and Demand to Dismiss, Right to Travel definitions, jurisdiction, and constitutional limitations on state police power. I think you were maybe supplementing your record. I ruled on all of those issues on Friday.
Yeah, I never filed that.
There's no new issues that I see that are before the court based on this memorandum. Do you want me to print this out for you and you can take a look at it, make sure I've addressed all of your issues?
Can I just speak on it?
Well, I've already made a ruling.
Okay.
So if there's any new issues that I haven't ruled upon, I'd be willing to do so. Do you want me to print this out so you can take a quick look at it?
Sure.
Okay, so she's speaking about this one here.
So I can't speak on the motion and the memorandum that I filed? No.
Well, I'm giving it to you, but it's everything I've already ruled on.
Okay.
And I'm not changing my ruling.
Right. So she's saying she ruled on it. At that point, you should have been like, okay, well, is there any, can I get a written determination in order to that? So findings of facts and conclusions at law, so I can understand why you have denied said memorandum. She's talking about this one right here.
Yeah, now I know to say that for sure. Now, after speaking to you on Wednesday, or, you know, yeah.
There's that, and it's a hearing. Like, I would have asked, do I have the right to be heard?
Right, because she said she already ruled on that bitch, so she didn't want to give him that opportunity.
I know, which is wrong. Like, he should have had the opportunity to be heard.
Yeah, he should have fought a little bit harder. You should have fought. Well, you just got to understand. That's why she's saying, like, sometimes, you know, like, maybe you need an attorney. And the only reason she's saying that is because you're not fighting on certain issues where you should be fighting on certain issues. That's all.
Okay, yeah.
If there's a new motion in there, right?
Instead of just saying, okay, you should be coming back with some kind of combat, right? Instead of acquiescing and just saying, okay, let's move it forward, you should be, you know, standing the ground a little bit more.
Didn't see.
It's par for the course. I get it. I've been there too. It's fear, a lot of fear going on in there. But once you settle in and start to understand your rights a little more and the procedures, like, you'll respond with confidence. It's part of the process.
I understand my rights completely. I don't know all the procedures when it comes to, like, court and going to trial and this and that. That's why I did decide to go ahead and seek a public defense attorney. Maybe they can argue all the facts better. Then I'll know exactly how it all goes. When I see it with my own eyes in trial, then I can fucking do it myself the next time.
No, there isn't.
Boy, brother, you gotta learn that game in the court right in front of them.
All right. Well, I'll make sure you have a copy anyway, but I think we're all, as far as the motions that have been filed and that the state has responded to on both sides, I think we're...
Yeah, that was just my response to what the state...
Right, they filed.
Yeah, yeah.
You were just adding more information.
And I
did review that, and it doesn't change my decision.
Yeah, and I was just, the memorandum for the right to travel, you know, just in case there was some information in there that you weren't aware of, you know, with all the U.S. Supreme Court cases, you know, verifying that I do have that right.
Yep.
Okay, you read it?
Yes, I did.
Okay, great.
Yeah, that's why I was a little confused, because I was like...
Pierce County Code itself, she read it, but she denies this. Road defines. Road includes all streets, highways, avenues, lanes, alleys, courts, places, squares, curbs, roads, and other public ways in the county which have been or hereinafter be dedicated to open to public use, or such other public property so designated in any law of the state.
I already addressed all those issues. I get that you're just kind of re-arguing, providing additional information to the state court, but it doesn't change my mind.
And Your Honor, so to clarify, the court's not finding any violations of 4.7 or Brady, and then in terms of the 8.3, has Your Honor made a ruling on that?
Oh, is that? Is that on the one that was about on the 13th?
Yes, Your Honor. And I addressed it briefly in the response I filed yesterday.
Yeah, and this supporting
statutory motion.
This memorandum that supports is kind of crazy. And she said she ruled on it and that she read it, but it's very clear and it distinguishes pretty much everything, bro. So to get a written determination on that one, she probably won't do because it's so strong.
Well, however, I mean, he's indicating that the discovery violations constitutes, you know, government mismanagement to the point of requiring dismissal. I didn't find any discovery violations, so I don't even think we get there.
Oh, understood, Your Honor.
Yeah.
Does that make sense to you?
Understood.
Okay.
That's true.
Right. So yes, I guess in a way that's true. Fine. Maybe I didn't verbalize it thoroughly. Okay, so that covers all of the motions. Now we're going to hold what's called a readiness hearing. Go ahead.
So yeah, you won't let me be heard on that motion in the memorandum?
You've been heard. You said that was in response to the state's response to your original motion. It was providing additional information to the court, additional points of law, arguments. I've reviewed that. I'm not changing my original ruling. I appreciate that you were responding to the state's response, but it doesn't change my rulings.
Okay.
Okay, so you can just rest on your brief.
All right.
It's there. Doesn't change my ruling. Okay, so now we're done with all the filed motions up until this date. Today is the readiness hearing. And I just wanted to hear from the state. Is the state ready to proceed to trial next week?
Yes, Your Honor, the state is ready to proceed to trial.
Okay. And what is your position, Mr. Bellick? Are you ready to proceed to trial on Monday?
Absolutely.
Okay, all right. And so now I'm actually going to go through a little bit more thorough waiver of your right to an attorney, because you have to file some things with the court, motions in limine, jury instructions before Monday's court date. You're going to have to know how to do voir dire, because I go pretty quickly when it comes to trials, because we only have 2 days to try these cases. And so there can't be any lagging behind or not knowing what to do. And if the state's objecting and I'm sustaining, you need to move on. And so there's going to be 20 people out here in the audience that are going to be our jury panel, and you're going to need to know how to select a jury. And if you don't, then
how.
I can't show you how or tell you how. There's going to be a lot of questions you won't be able to ask them, and so the state will object when they feel like they need to object, and I'll make my ruling, and you'll need to ask another question. You're going to need to know what that process is. The way I do it is I allow you to do your peremptories throughout the panel. I don't seat the first 6, and you have to go within the first 6. You can go throughout the entire panel. You'll have 3 peremptory challenges. 1 additional one, because I always seat an alternate juror, so there'll be 7 potential jurors. You'll need to know what the bases are for good cause objections, GR 37 objections. You'll need to be able to do that come Monday morning, because what we're going to do is we'll handle motions in limine that the state's going to file. They're going to give you a copy. You'll need to file yours. We're going to handle those first thing in the morning. And so how many state's witnesses?
Your Honor, the state anticipates approximately 5 witnesses, I believe.
Okay. And I did not see that the defense filed a witness list. Is that correct?
Yeah, I don't have any witnesses.
Okay. And the way, so you'll get the right to cross-examine each of the witnesses. The witness will be right here. The jury's going to be over there. And so you'll need to make sure that you're prepared for those witnesses, because there's not going to be a whole lot of time for you to sit and think. I'm not saying they have to go bam, 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 but I have to keep this moving, especially with 5 witnesses.
Okay.
And so you'll get to decide whether you give an opening statement or reserve opening statement after the state rests. And then you'll need to make a decision. You don't need to make that now as to whether you are going to testify yourself. If you decide to testify yourself, I'm not going to allow, and this is going to be awkward for you, but I don't allow this, just this colloquy for you to just give information. You're going to have to ask yourself questions and answer them, because they could be objectionable questions.
Okay.
And the state has the right to know what you're going to say.
Yeah.
And so it'll have to be in that format.
Okay.
And then I ask for motions in limine to be supplied to the court by Friday at noon. And then jury instructions morning of.
I don't intend to testify myself.
Well, you give that. You don't need to tell me now, but and I don't know if there was a need for a 3-5.
Your Honor, at this time, I'm not sure. I selected it on the readiness form just in case the state would like one. However, this time I'm not sure, Your Honor.
Okay. All right. If we do, I would like to start the 3-5 hearing at 8:30.
Oh, understood, Your Honor. Thank you. And I'm handing the declaration of trial readiness to Mr. Golick right now, so he can select if he needs any special equipment or anything else.
The process. A lot's in here. A lot is in here.
And I will go over your waiver for an attorney day of trial as well, just so you know.
I'm sorry, I didn't hear you. What?
I said I will be going over your waiver of right to an attorney day of trial as well.
Okay.
For jury selection, you can ask the jury if they believe you're innocent. Raise their hand. Nobody does. They're all dismissed.
Talk on that some more because I'm still learning a lot.
Because you have the right to be innocent before proven guilty.
Didn't think about that.
For jury
And that,
selection. Mm-hmm.
and that
That's
would
that
make them.
question.
It's got to be a jury of my peers, and that would make them biased if they don't think I'm innocent.
So
So
you,
they already have a presumption that I'm guilty.
Presumption of, yeah, you have an irrebuttable presumption of guilt on information.
so you could dismiss anybody who did not raise their hand if you asked them if they assumed you were innocent.
Before proven guilty.
I know it's a thing, but where could I go to find that innocent before proven guilty? That's something that I have tried to look up in the past, but never could.
Your Honor, I'm bringing up the declaration of trial readiness.
I'm going to do a duck search now.
Yeah, so we got a situation of jury trial instructions. We got information on limine, witness lists, pretty much all that good information. Let me see what else my book.
Look at that. We booming. We banging. We all up in this thing.
Let's see what.
Man, and then, when I filed that Nisi Prius document and then I filed all my state national documents, I remember I sent you the state's response to that. She didn't respond worth a shit to the Nisi Prius documents, and then she's trying to not even let none of my state national documents even be heard at trial at all. Because, I'm a state fucking national, I'm a state citizen.
So this morning filed that emergency petition for writ of mandamus in the Pierce County Superior Court, and this court is on notice that a superior tribunal is being asked to stay these proceedings. For all these reasons, I'm not ready for trial, and I respectfully move for a continuance, please.
Let's see if I can download this bad boy, because barely hear her too.
Yeah, that was just on Wednesday at the readiness hearing when I filed everything you had me file. Yeah.
Are we at the point of filing crimes in the federal for what the lower court is doing?
I'm just trying to get through this trial, man, first. I don't know.
I don't know, Cam. What do you think? There's obvious plenty of rights violations.
Yeah, they're railroading me, bro. No doubt.
Just throw something in the federal with all the evidence you have.
Well, I don't want to say that they're railroad. Well, I don't want to say that they're railroading you. I just want to say, like, on certain situations, maybe it should have been. You should have gotten a written determination. It seems like you did just get a written determination, which Joe kind of just replied to in a sense. I've already got something built up as well. But requesting written determinations on all of these denials of certain things is very important. Setting in the motion in limine and then getting that evidentiary hearing would have been very important as far as a cross-examination or even trying to interview them.
I filed a motion in limine on the Friday before I was supposed to go to trial the first time. Yeah, Joe helped me with that, and I filed it, and then that's when I tried to go get the copy of the video footage, and they didn't have it, and then got emailed an empty folder that day, so that's why the trial got pushed forward.
Well, at least you got a motion in limine in, because she did say you needed to get one in before Friday. So
by Friday at noon, before on the 18th, before my trial was supposed to be like, on the 21st or 3rd or some shit of March.
Okay.
So there's a few more steps to get a solid basis into federal.
Okay, so the emergency situation on the analysis is that the judge has issued only oral denials of every pre-trial motion. This is a critical procedural defect that creates the following legal landscape. What the judge has done wrong under CRLJ 8.2 and State versus Cunningham. Okay, so we got this one. Save that. Use MP4. Oral denials of suppression motions are legally insufficient. Written findings of facts and conclusions at law are mandatory. Without them, there is no final reviewable order under RALJ 2.2, and the entire proceeding is constitutionally defective. What this means strategically. The judge's refusal to issue written findings is not just an error, it is the engine that powers every avenue to halt this trial. Every document in this package flows from that single defect. The three-tier attack. File in this order. The Superior Court file immediately today. Emergency notice of appeal and motion for stay. Under the vehicle of RALJ and CRLJ, Criminal Rules of Limited Jurisdiction. 8.2, invoke the Superior Court jurisdiction. Oh, we got the second one. Stay of trial. Second document, emergency application for discretionary review. That's under RAP 2.3B2. Alternative route to Court of Appeals, request stay of trial. You take them to Superior Court, ask for an emergency hearing, tell the clerk today is Monday, I need an emergency hearing on stay. District Court file at the start of trial, Monday. Formal objection to proceeding without written findings. CRRLJ 8.2, under due process. The effect is that it places the court on a formal written notice, creates a reversible error. Uh-oh, I probably just went back on accident. Yeah.
So Cam, if we listen to that second audio from on Wednesday's hearing, when she went ahead and ruled on everything that I filed an emergency, yeah, she said, if you do decide to get an attorney, let the prosecutor know right away. And then so she could call off the fucking jurors and call off the fucking pigs to come on Monday. So, yeah, as of right now, because I filed that financial declaration to try to get a public defense attorney now, so we're not going to have trial on Monday at this point. But I have to go in there at 8:30 in the morning to just to show up, I guess.
Yeah, because then you got tier 2 is the district court file at the start of trial, formal objection to proceeding without written findings. Again, it places the court on formal written notice and creates a reversible error. The renewed oral motion script renews all pretrial motions and record before the jury is seated. Then tier 3 in trial record preservation during trial on Monday. The in-trial objection script is complete. Okay, phase guy by guy. Then the single most important thing Brett must do, regardless of whether Superior Court grants a stay, Brett must say these exact words at the start of the trial. Your Honor, I formally object to this trial proceeding. This court denied my motion to suppress orally without entering written findings of facts and conclusions of law as required by CRRLJ 8.2 in State versus Cunningham. I'm appearing under duress, exemption noted for the record. Okay? That sentence on the record is the foundation of the entire appeal. If she says nothing, the issue may be deemed waived. If he says those words, the issue is preserved and the conviction is reversible. Why the strategy works, even if everything is denied. If the trial proceeds and Brett is convicted, the RALJ appeal to Superior Court will be based on the following preserved errors. The district court denied a suppression motion without written findings, a reversible error under Cunningham. The state never rebutted the sworn affidavit, jurisdictional defect. The state never, we can't say the state never responded to the bill of particulars because they did. The stop was pretextual, which she says she denied, and the DOL interlock order was ultra vires. The underlying suspension was void. Any of those 5 grounds is independently sufficient to reverse the conviction on RALJ appeal. So you got the emergency notice of appeal, application, formal objection, no written findings, then in-trial objection script and renewal of oral motions, right? So we got that kind of concept. Then you brought forth, then you brought forth the written findings from her, right? So we had a review of that and the analysis of the state's proposed FFCL, I guess key findings. The state's proposed FFCL submitted by Deputy Prosecuting Attorney, I guess this wasn't written findings then because, yeah, that was the last thing you gave me. So let me check one more time what that was. Boom.
I just put that on my at the bottom of my Discord channel this morning, and I emailed it to you.
Yeah, I thought I seen it, and I thought I downloaded it and put it in Manus, but I don't know.
That's it right there. Yeah.
Let me check this one more time.
But hey,
this is the FFCL.
Yeah, if we listen to the second audio of that day, that's when she ruled on everything, and I went ahead and said the things I need to say for appeal and everything at the end there. I mean, I followed the script to a T,
Okay, so this findings of facts and conclusions of law is brought forth by the deputy prosecuting attorney. It's not brought forth from the judge.
Yeah, so if you want to listen to that audio, it's like 23 minutes, man, from Wednesday.
Okay, hold on.
That's the last
All right. So the analysis of the state's proposed FFCL, findings of facts, conclusions of law, and key findings. The state's proposed FFCL submitted by the deputy prosecuting attorney, Alex, contains 7 critical legal deficiencies that must be challenged immediately. Deficiency 1, the sovereign citizen bias trap. Most important, the FFCL characterizes Brett's arguments as sovereign citizen ideology. Boom, that's a big one right here. In the disputed facts section. This is a deliberate prejudicial label designed to cause the court to dismiss Brett's legitimate constitutional arguments without analysis. This is precisely the judicial bias issue that was the subject of Exhibit C. The objections document addresses this directly and frames it as a due process violation. Deficiency 2. The RAS finding is legally insufficient. Finding of fact number 4 states Deputy Gates had RAS based on the private plate. However, RCW 46.16A.030 is a registration statute. The offense is operating without registration, not displaying a non-standard plate. The officer would need to have verified the absence of registration before the stop to have RAS. The FFCL contains no such finding. Deficiency 3. The pretextual stop finding fails areola. The finding of fact number 6 says the stop was not pretextual, but State versus Areola in 2012 requires the state to find that the traffic infraction was an actual, conscious, and independent cause of the stop. The FFCL makes no such finding. This omission is reversible error. Deficiency 4. The jurisdictional conclusion assumes the disputed fact. Conclusions of law number 1 says Brett was subject to RCW because he was operating a motor vehicle. But this is the exact fact Brett disputed, and the FFCL never resolves the dispute. It simply adopts the state's position without analysis. A court cannot resolve a factual dispute by ignoring it. Deficiency 5. The unrebuted affidavit is entirely ignored. The FFCL makes no mention of Brett's own sworn affidavit. The state never filed a counter affidavit. Under United States versus KISS 1981, unrebuted affidavit are taken as true. The state's silence is an admission. Deficiency 6. The Bill of Particulars ruling conflates 2 distinct legal concepts. Conclusion of law number 4 denies the Bill of Particulars because the charging instruments are sufficient. This is legally wrong. A charging instrument and Bill of Particulars serve different purposes. In State versus Gavorsic, requires specific notice beyond what the charging document provides. Deficiency number 7. The Brady conclusion has no factual support. Conclusion of law number 5 says the state met its Brady obligations. This is a blanket legal conclusion with 0 factual findings. What was disclosed? When? What was the exculpatory material identified? None of this is in the FFCL. Signature block warning critical. The state's FFCL contained a line approved as to form Brett Golick, defendant pro se. Brett must not sign this document under any circumstances. Signing it would be interpreted as approving the state's version of the facts and potentially waiving the right to object. Instead, Brett should file the 3 documents in this package as his formal response. Defendant's objections to state's proposed FFCL. Defendant's counter-proposed FFCL. Memorandum of law in support of objections. Case law validation document and research notes. One critical caveat, RCW 46.04.320, the case law validation document flags an important nuance. RCW 46.04.320 does not explicitly limit motor vehicle to commercial use. The commercial use limitation is a constitutional argument, right to travel, traveler versus driver distinction, not purely statutory argument. This document frames it correctly as a constitutional argument, but Brett should be aware of this distinction when arguing with the court. So that's not a factual findings and conclusions at law from the judge. It's actually just one that's being proposed to be adopted by the judge from the state in and of itself. Okay, so I just wanted to make that distinction really quickly. And then we have both of these videos that we just downloaded.
With all that, you could be filing into federal for a stay.
Brett, date modified, 1003. We got 2 different ones here, so let's see which one. Open with VLC.
Is that the one on Wednesday, the 23-minute one?
Brett Raymond Golick, copy numbers 5AC003163 and 5AC003162. DPA out strike for the state of Washington. The defendant is present, out of custody, and is currently representing himself in this matter. This matter is before the court this morning for a trial readiness hearing.
Okay, and the state ready to proceed?
Yes, Your Honor, and the state would be declaring ready at this time.
Okay, thank you. All right, Mr. Golick, I'm going to have you state your full name.
Brett Raymond Golick, appearing specially and not generally in prior persona, sui juris, reserving all rights.
Okay. All right, so this is a readiness hearing, and the state is declaring it ready for trial on Monday. And I know we've gone over your waiver of right to an attorney.
attorney many times in this case, so I'm not going to go over it as thoroughly. I think you are making a knowing voluntary waiver of your right to an attorney present. Are we still of that same mindset of you wanting to proceed pro se?
Yes, Your Honor. Before this court proceeds to a readiness hearing, I respectfully move the court on an emergency basis. This court denied multiple dispositive motions without issuing any written orders, without making any findings of fact, and without stating any conclusions of law. I'm filing today concurrently with this hearing a formal notice and demand for written findings of fact and conclusions of law. Without a written record of this court's legal reasoning, I'm constitutionally precluded from seeking appellate review of those rulings. I'm also filing today an emergency petition for writ of mandamus in the Pierce County Superior Court, together with a motion to stay these proceedings. I'm formally requesting a continuance of this readiness hearing and the trial until the Superior Court has ruled on the writ. And I want to file these with the court today. I have some motions here, and can I get copies, please, for my record?
Well, first of all, did you serve those motions on state?
I just want to file them today. I just got them put together yesterday on an emergency basis, so I literally.
Let me see what you have.
Okay. I have an emergency motion for continuance, and I have some other motions too.
I think what I'm going to do is next time you need to come prepared with copies. This is not our job to be making copies and serving the state. You need to make sure that you serve the state all motions, all documents, whatever it is you're submitting to the court.
Okay, I apologize.
And so I'll do it this one time.
Okay.
But,
thank you, Your Honor.
I want the state to review those.
Now, as far as the writ of mandamus for the Superior Court, I tried to go down there and file it with him, and he said, you got to file it with you guys, I guess. Your Honor, with respect, this case is not.
One step at a time.
Oh, okay. Okay.
I need the state to have a copy of your motion so they're aware of what you're motioning the court for.
Okay, thank you, Your Honor.
Do you have a copy of these?
No, that's why I need to have you making me a copy with a stamp on it, please. Thank you so much. I got this writ of mandamus too. This is the one that I tried to file with the Superior Court, and you said that I had to file it with you guys. Thank you.
Hey, baby.
I understand. Thank you so much.
So, Brett, you end up filing an emergency motion to suppress, emergency motion for a continuance of trial and readiness hearing. You also filed a renewed motion to dismiss for failure to respond to the bill of particulars, which they did. I don't think maybe you filed that, maybe you didn't, but they did respond to the bill of particulars. And then the notice and demand for written findings of fact and conclusions of law, which the state just filed, but you were asking that the court file that. You filed all this just on this date here?
Yeah, that during those 13 minutes, and then the judge had to take a recess, and then the prosecutor bitch took off for a little while, and then they went over everything, and then we came back, and then we talked about it for 23 minutes, and then went over everything.
That's the other one. All right, so let's go.
That's the second audio of that day. Yeah.
Yeah, let's get into this.
And I emailed it to you.
Yeah, I got it.
Yeah.
Okay, so y'all took a break.
Yeah.
Then they came back.
Yeah.
This was set for readiness hearing. Mr. Golick, you have presented the court with several documents here regarding our case. I think we can handle them one at a time. So the first one we're going to address is the emergency motion for a continuance of the trial in readiness. That's kind of the first step here. So I'm going to allow you to make your record. I've read your motion, and then I'm going to allow the state to respond.
Okay.
So we're just addressing the continuance request.
Okay.
So I'll let you make the record.
Okay, Your Honor, with respect, this case is not procedurally ready for trial. I'm not in a position to declare readiness when, first, the court has not issued written findings of fact and conclusions of law on any of the depositive motions, depriving me of my ability to seek appellate review before trial. Second, the state has never rebutted my sworn affidavit. An unrebutted affidavit stands as truth in the record. The state's silence constitutes acquiescence to the facts I've asserted, including that I was not engaged in commercial activity and that this court lacks subject matter or lacks jurisdiction over my private travel. Third, the state has never provided a legally sufficient response to my bill of particulars. I do not know the specific factual basis which the state claims jurisdiction over my private travel. Fourth, my emergency motion to suppress has not been heard on the merits under CRRLJ 3.6. Suppression motions must be determined prior to trial. And fifth, I have, this morning filed that emergency petition for writ of mandamus in the Pierce County Superior Court, and this court is on notice that a superior tribunal is being asked to stay these proceedings. For all these reasons, I'm not ready for trial, and I respectfully move for a continuance, please.
Thank you, Your Honor. And the state would be asking the court to deny this. State was ready last time. State's ready again to proceed this time. I think we probably discussed in court that all motions need to be filed 14 days prior to readiness. At this point, I think if this doesn't go to trial, we're just going to keep doing this thing where new things keep being filed. And once again, I think that...
Let's just address the continuance.
Thank you, Your Honor. So I'll stop now. Thank you.
All right, so Mr. Golick, this is where I told you you are proceeding at a disadvantage. Because you don't have an attorney here, you're not trained in the law. You're indicating to the court that your case is not procedurally ready to proceed to trial. It's all motions that have been filed. You can't continually keep filing motion. We set deadlines for a reason. I did hear the dispositive motions. I made rulings on those. I'm not going back to readdress that. You do have, at some point, the right to appeal, but you can appeal if convicted of these charges. We will make sure that findings of fact will be in writing. I made an oral ruling, which is at this point is the only thing that's needed. But I will make sure that there are written findings as it relates to your 3-6 motions that you have brought and I've already ruled upon. That will allow for you, if convicted at trial, to appeal my decisions and potential conviction to Superior Court. That's kind of the way that goes.
Okay.
And so it is procedurally ready. The findings right now are kind of moot. I did make an oral ruling. The state's discovery failures, prejudice.
Right there, she said the written orders are moot. I made an oral determination. No, Your Honor, excuse me. I object. They're not mute. For me to have my due process and understand why you denied those, I need them in a written format. That's the whole point of why I've requested those under 3.6. So, yeah, I mean, some of these things you gotta not acquiesce to and accept. You gotta rebut that shit,
You've been provided everything that the state has in its possession. We've talked about this at the last hearing. I think You were given all of the video as it relates to your stop here in open court. I think that was the last little piece that was missing. And so I don't see that if the state brings additional evidence during the course of the trial that is new or whatever, then that's something that would be, you can address at the time, because then at that point, the state, you could make a motion and then the court could exclude it because they didn't provide it to you in advance. That they have provided everything to you that they intend to present to a jury and to the court. And then, just looking at your face, I think, so at this time, there are no discovery violations. I've made my rulings on the bill of particulars, so it is procedurally ready for trial. I'm going to deny your request to continue.
Your Honor, I object to the denial of the continuance, and I place this court on formal notice of the following. 1, I'm preserving all issues for appeal and for the writ of mandamus currently pending in the Superior Court. 2, I'm renewing my emergency motion to suppress all evidence obtained as a result of the pretextual stop under State v. Ladson in 1999, Article 1, Section 7 of the Washington State Constitution.
Mr. Golick, I'm going to interject here. You have made that record previously. I made my ruling on the motion regarding the pretext stop. I've made my ruling on all of the motions that you brought before the court, and your objections were noted at this time. So there's a clear record from the last time about your objections to my ruling. So there's no need to keep reiterating.
Okay, I apologize.
No, that's fine. And see, this is how you're proceeding at a disadvantage because you're not trained in the law, and you've never been gone through a trial, and so representing yourself, and I'm going to keep encouraging you to maybe entertain the idea of having a public defender.
Okay, or I might have to get a private attorney, possibly.
Well, we're set for trial.
Monday. Okay.
I mean, if you're looking into a private attorney, that's your right. You have the right to an attorney, and that will be a different story. We'll have to look at that Monday morning. But if you want an attorney free of charge to you, we have public defenders.
Misrepresenting the law.
And so we're continuing with the trial as scheduled. So it looks like your motion to suppress, I mean, all of these documents are kind of renewed motion to dismiss. There's nothing new here. I've ruled on every legal argument that you brought forward to the court.
With my renewing my motion to dismiss based on the state's failure to rebut my affidavit and failure to respond to my bill of particulars in a sufficient manner, and any unrebutted affidavit stands as truth. The state has admitted by silence that I was engaged in private non-commercial travel and that this court lacks jurisdiction. 4, I'm renewing my challenge.
Mr. Golick, we've ruled, these are the same arguments you brought before that I ruled upon. Your objection is noted, okay?
Thank you.
And you made a really clear record the last time, and so it would be sufficient for any appeal purposes in the future.
Okay, thank you, Your Honor.
Let's talk about trial on Monday.
Yes, Your Honor, and I have filled out the declaration of trial readiness. State's witnesses are available both days. I'm passing that to Mr. Golick.
Okay.
Your Honor, I formally object to the commencement of trial. I'm invoking my right under CRRLJ 3.6 to have my pending motion to suppress heard and determined before trial. Okay, and I'm invoking my right under the 6th Amendment in Article 1, Section 22 to be informed of the nature and cause of the accusations before trial, and I'm invoking my right under the Due Process Clause to have this court's rulings on my dispositive motions reduced to writing before trial, please. I'm also formally notifying this court that proceeding to trial under these circumstances will constitute a violation of my fundamental creator endowed rights, and I will be raised as reversible error on appeal and in the pending writ proceedings. I'm making this record under protest and under duress, and I'm not waiving any of my rights by participating in these proceedings.
Actually, it's pretty good. I ain't gonna lie, you're doing actually pretty good. You're doing pretty good. Brett, I'm not.
He's killing it. He's fucking killing it.
Yeah, I'm not gonna
Go,
Brett. Yeah,
hey man, your boy can read off the script, no problem.
Yeah, baby. But you got it on the record. You got it on the record.
That's a fucking
like Carl Miller says, if you don't talk fast, you lose.
The only thing he missed was bitch in front of some of his statements.
Well, yeah, I got to be a little respectful in court. I want the judge to like me, and
Right. You're not fighting the judge.
Absolutely.
You actually
the administrator's your friend.
You
got to find out what the prosecutor is doing.
You actually doing all right, Brett. I'm proud of you, bro. You actually doing okay.
I would have loved to read her mind when you said
I want to see the administrator's face.
Well, it's funny because she keeps saying we've already gone over this. I've already ruled on it. You've already made your objections, but clearly, I don't think she has ruled on a motion to suppress
No.
because this was the first time that you've even brought up a motion to suppress. So for her to state that she ruled on a motion to suppress is kind of crazy because you never put in a motion to suppress.
Well, remember, I think I did put in something about the motion to suppress for the fruit of the poisonous tree or something like that. I think I did put something like that in the record.
Okay, so as of 3 months ago, you got a notice and demand to dismiss, an affidavit, bill of particulars, motion to challenge the DOL error, motion to dismiss supplemental bill of particulars, compel response to no, bro. I don't see.
Oh. Okay.
Well, you got this motion to suppress, which was 3 days ago.
Yeah, but remember, that was did something with the fruit of the poisonous tree, and we were trying to suppress some of the evidence. I remember that.
Well,
what dispositive mean in this case when you keep saying dispositive motion?
The fact that you may have brought forth the argument within a motion or a notice and demand to dismiss, you still didn't get your evidentiary hearing, though.
Right.
So when did she decide that you're not entitled to an evidentiary hearing?
Probably right in this hearing, I guess. Because we put forth a evidentiary hearing, and she ain't having it.
Briefly address the 3.6. When would Your Honor like those proposed findings of fact and conclusions of law?
I think it would be best to have that filed the morning of trial.
Okay, thank you, Your Honor. And would you like it to encompass all of the motion hearings as well as today?
I don't think, there was really no motions, substantive motions, or any sort of...
Right, I just want to make sure that it has everything that the parties have discussed. I'll go back and I'll listen to those hearings and I'll file those with the court prior to Monday.
I want to take a look here. And there's some that are clearly, that would fall under 3.6, like the pretext stop. It's been quite some time since I ruled on these motions. There was the bill of particulars. I don't think that really requires written findings. That was, my oral findings was enough on that.
Oh.
Let me take a look here.
What up, Cam? Shout out.
What's up? What's up, Ricky?
Just getting out of a meeting. Good to hear from you.
You as well, brother. We're in a court hearing right now.
All right, I'm gonna pay attention. Thank you.
Yep. We're in a hearing.
And can someone tell me what the word dispositive means? He used it 3 times.
It means when they disposed of something. Case been disposed of, a charge been disposed of.
Okay, so we got a dispositive motion as a pretrial court filing that asks the judge to resolve all or part of a lawsuit immediately or any kind of situation, bypassing the need for a full trial. These motions, which include motions to dismiss and motions for summary judgment, argue that there is no genuine disputes of material fact and that the law requires specific judgment. So the key aspects of dispositive motions, the purpose is to eliminate the cost and time of trial by ending the case early, often due to legal laws or lack of evidence or just a procedural error. Of course, the types are motion to dismiss, a motion for summary judgment, a motion for judgment on the pleadings. Why they are filed is, the outcome is, of course, if granted, the motion can result in dismissal of the entire case or specific claims. When they are filed, motions to dismiss are usually filed early. Dispositive motions are critical to the litigation strategy, allowing parties to end the lawsuits or the claims or the charges prematurely if the other side cannot show a valid claim or a genuine dispute of the facts.
So we mostly file dispositive motions.
Correct.
Mostly that's what we do.
Yep.
Okay.
Yep, but it should be that we're filing dispositive, or it should be that we're filing notice and demand, which bring us under the constitutional framework rather than the 3.6, which is statutory,
Agreed.
which is what the court
Yeah,
actually
8.6.
stated. Yeah, she actually stated, she was like, yeah, we're
Mhm.
viewing everything under 3.6, right? So,
Motion to suppress and dismiss.
Oh,
well, what
3.6
did she say to this?
constitutional?
What did she say? She said something about motion to suppress.
I guess what the court would be requiring is just in regards to any motion to suppress and dismiss.
Understood.
Yes, may I say something? The state filed a response to my judicial notice argument ER 201 and 401 and ER 403. Your Honor, the state's response to my demand for judicial notice is legally deficient in 3 respects. First, the state argues that the 1940 joint resolution is not subject to judicial notice.
Well, hold on, I'm going to interject here.
Ah.
The way I kind of viewed the documents that you filed with the court is something along the line like maybe a motion in limine. This can all be handled morning of trial because it's. I don't think it's something that needs to be heard right now.
Oh my
So
God.
you received the state's motions in limine, right?
Yeah, before we were about to go to trial the last time, yeah.
So we will address the documents that you filed and the state's response morning of trial along with all of the state's motions in limine.
And Mr. Goff, the state won't be filing any additional responses. I think I've said everything I need to say in my written findings already, so I'll just be sending the findings of fact and conclusions of law.
Okay, thank you.
All right. So I think Ms. Greif just handed you the trial readiness form there. I just need you to review that.
Okay, may I make a closing statement for the record, please?
Go ahead.
Okay, Your Honor, for the record, I'm formally preserving the following issues for appeal and for the pending writ of mandamus proceedings. 1, the denial of all dispositive motions without written findings of fact and conclusions of law. 2, the denial of the emergency motion for continuance. 3, the denial of the emergency motion to suppress without an evidentiary hearing. 4, the state's failure to rebut the sworn affidavit and the state's failure to respond to the bill of particulars in a sufficient manner. 5, the court's failure to take judicial notice of the 1940 joint resolution and the established constitutional right to travel. 6, the court's subject matter jurisdiction over the private non-commercial travel of a sovereign individual upon roads that the state itself defines as open as a matter of right to public vehicular travel under RCW 47.04.01013. I respectfully submit that this prosecution is constitutionally infirm from its inception and that the appropriate remedy is dismissal with prejudice. I am making this record to ensure that the Superior Court and the Court of Appeals have a complete record for the constitutional violations that have occurred in these proceedings. Thank you, Your Honor.
Hell yeah, bro. Hell yeah, bro. Go get him. Go get him. I'm happy, bro. I'm pretty happy you're making. Yeah. Yeah, you're
And
making
on the record.
They can't blanket denial that either because they'll be violating Title 18, 2381.
What's 2381?
That they are supposed to move quickly in defense of the Constitution or be committing treason.
Okay.
I got Carl. I got it pulled up.
Yeah, 18 U.S.C. Section 2381 defines treason against the United States as levying war against them and or adhering to enemies, giving them aid and comfort, and convicted individuals. The key aspects, definition of the state applies to anyone owing allegiance to the U.S. who levies war against it. You're reaching there. But, I mean, maybe if you want to apply it.
They're supposed to move quickly in defense of the Constitution.
Maybe reaching there. I think some of the things that Homeboy could have applied was that, like was it Hayes versus Kerner? Hayes versus Kerner? Which is that everything that you are stating is supposed to be liberally construed, so they're both supposed to be, a little bit more in favor of you. And I mean, but she is kind of being lenient. She is explaining a lot, but the fact that she did just blanketly deny everything, I don't know. Let me see how she's finishing the rest of this motion. I want to see how she finishes the rest of this motion to suppress, because she stated it, but then she kind of backed off on it too.
See any pending motions before the court as it relates to a motion to suppress or dismiss. What motions eliminate are, and what has been given to you by the state will be heard Monday morning. It's basically what motions eliminate.
What motions eliminated did they get? I didn't get motions eliminated. Did you give me one?
Yeah. Well, I don't know. I never sent you that. But
Why? This nigga. Why?
I filed it. I filed one, and I can send you the state's response right now.
Oh, you filed one. I don't got it. I don't got what you filed.
Yeah, because you were in the hospital at the time. Joe was helping me at the time.
Oh, my ass was broke down?
Yeah, you were broke down and shit.
I had a flat tire. Yeah, I had a flat tire. Yeah, I had a flat tire.
Advising you that it's just to exclude or limit certain evidence from being presented to a jury, just to prevent any unfair.
Just to show y'all my flat tire real quick. I don't think I showed it to everybody. I think I showed it to a couple people though. Accident. So I got a 911 call finally on it. I'm not gonna play it, but the dude that made the 911 call was like, "Yeah, this guy had a motorcycle wreck. I don't know if he's if he's unconscious or he's dead." Oh man, it was crazy. Okay, let me see. Where is the one I'm looking for? It's probably up here. Okay, yeah, it's probably this one. Okay, yeah. So I got these pictures not too long ago. I guess on the 24th. Come on, man, just show it, bro. Okay, so on my wreck, I first hit here on this. Let me see, on this embankment, but then I went through this barbed wire fence. So I hit right here first, and then I came up here and hit somewhere right here second, and then I hit this little mountain hill right here. So then let me see, boom. Where are we at next? Where's the little hill? So this little little hill I hit right here. I think this is where it flung me over to the left side, and then the bike goes rolling end over end. Okay, so then I'll show y'all. And the reason I say the bike probably went end over end is because on this picture you can see that you can see all the wires wrapped up in the bike, right? You see all the wires wrapped up in the bike, the wires wrapped up in the bike. But then the back end is all up. You see how the back end's all up? So I think this bad boy went end over end, did cartwheels, and then my ass just ended up way over there. My ass just ended up way over. Man, come on, show me. Where is it? Boom, 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 boom. Where's it at? I guess that's the closest one. It's one of these ones. Man, my computer going so slow. Come on, man. But yeah, I guess I just got flung way over there. I don't know, so about 25 feet is where I got flung to. I guess they put the black bag up under you. That was scary because they had this black bag. It made me look like I was dead, bro. That scares me. But I guess they just put it up under you so that they can lift you. I guess that's the case. All right. My ass was broke down.
Prejudice or confusions or certain arguments that should or should not be made in front of a jury. And so that's what we will decide. And then I do see that you had filed those trial documents that you're going to be wanting to use during the course of trial. We'll address that Monday.
Okay.
So whether it comes in or not, that's the whole purpose of motion.
Now they're talking about what trial documents will come in. They talking about are they talking about your national shit? Where'd he go? Brett.
Yeah. They're talking about my state national documents and the Nisi Prius document that I filed.
Oh, okay.
It's eliminated before any trials to decide in advance. And so I will, state has responded to it. They've given you a copy of that. That's their argument. I'll make my rulings on that Monday morning.
Okay.
And so as I mentioned before, Mr. Golick, we're going to start at 8:30. And, there is a process where we select a jury. And you need to, I'm not even certain that you're aware of what's appropriate and what's not appropriate when selecting a jury, what types of questions can be answered. I'm only going to discuss procedure with you on how that is to go. I can't give you any legal advice. The state can't. You're proceeding at a huge disadvantage. If you want to hire a private attorney, that is your right. And then if you do so and that attorney appears on Monday morning, we can readdress whether it should be continued or not, because that attorney won't be ready to go. We wouldn't have reviewed all of the evidence and or even have an opportunity to negotiate with the state. I'll reiterate that you do have the right to a public defender, and I'm willing to appoint you a public defender right here and now.
I've been in contact with an attorney, so I might be going ahead and seeking private counsel.
Okay, and you have that right.
And I
Just
gave him
make
all
sure
my documents and
if
everything.
you do, that person needs to file a notice of appearance.
Okay.
And be present on Monday.
Yes,
in order
ma'am.
for me to even entertain a continuance. If you show up on your own, indicating, well, I think I have somebody that I want to hire, you've had plenty of time.
I know I have.
Yeah.
Yes, ma'am.
And so we will proceed with the trial.
Okay.
I would appreciate it if you do hire an attorney in the next few days.
Let her know.
Yes, please let her know who that is. That way they can start discussions and kind of move things along. So this is not, the attorney would not be ready to go on Monday and be asking for a continuance, no doubt. But please let Ms. Greif know so she knows to potentially call off witnesses if it's necessary.
Yeah, I'll let her know right away.
And then we also have a jury panel that we're requesting, and when we show up on a Monday morning and a jury panel has been requested, we have to pay for that jury panel.
Yeah.
So as soon as you know that you have an attorney on board, they're going to file a notice of appearance, let Ms. Greif know so she can cancel the witnesses, let the court know so we can cancel the jury panel, so we're not on the hook for paying for a panel when this matter's not.
Yeah, I'll let her know right away.
All right.
Yes, ma'am.
Go ahead, take a look at that document. We're going to file it. We're going to be back here Monday at 8:30.
Okay, thank you, Your Honor.
Mm-hmm.
That's it? Is that it in the hearing?
Yeah.
So the rest is just silence?
How much more of the video is on there?
About 4 minutes.
And Your Honor, I know that another
A little more.
trial is set in this courtroom for Monday. Is there a possibility that this matter will be heard before another judge, or do you think it's likely
I'm
to
going
be
to
this
hold,
court?
I will, if both cases go, I'll probably find someone to preside over the other case. I would not want to, I'm very familiar with it. I think it's best that I remain in this one.
Thank you, Your Honor.
All right, who do I do the copy?
Oh, I can take that. Thank you.
And just so, and I don't know if I mentioned this to you guys, but I mentioned it previously, on Monday, if this proceeds to trial, we'll be recessing at 1:30 for the rest of the day on Monday. But would have a full day of trial. Tuesday, if it goes into Wednesday, that's a possibility as well.
Okay, thank you, Your Honor.
Thank you, Your Honor.
So it looks like the only thing that we would be handling, first thing in the morning would be there's a potential 3-5 hearing that needs to be heard, and then motions on limine.
Motions on limine, see? That's what she says.
Yes, I'm trying to find the state's motion. I think I sent you mine.
Oh, yeah, you had already filed one. I made one over here, but where's the state's response? Let's see. Shared open.
Trying to find it.
See what you got.
So, yeah, even if they do a conviction, you have remedy.
Okay, so you got...
No big deal, Zach.
Where is...
I hope so.
I can't zoom it in. Where's the easy zoom? Tools. Bruh, they be tripping. Guess I'll just do it like that. Okay, so evidence must be relevant to be admissible. Even relevant evidence may be excluded. A witness testifying only matters within personal knowledge. Must be authentic. All documentary evidence must be authenticated prior to admission. The state further obligated to disclose exculpatory, exclude conclusory testimony regarding statutory elements. Statements such as defendant was driving, operating a motor vehicle in violation or obstructing are legal conclusions unless supported by specific articulated observations. Witness must testify to facts, not legal characterizations. Require proper foundation for statutory application. State bears the burden of proving each element. Exclude undisclosed evidence. Require authentication of administrative and documentary evidence. Exclude evidence more prejudicial than probative. In conclusion, I mean it's okay. I'd have got more detailed with it, but it's okay. Yeah, because you wanted to bring forth more of the hearsay with a proposed order. It's okay though. This one's a 11-pager, but that's because it's got the proposed order too. Okay, and then you already got a response for their motion in limine?
Man, I'm trying to. Oh, no. Actually, we never even heard the motion to limine. I filed one, and the state filed one on Friday before noon. That was before we were supposed to have trial on Monday, March 23rd, I think.
Where's the one that they found?
I'm trying to find it, man. I can't find it right now. I'm trying to find it here. Fuck.
It's okay. Don't trim. Did I already develop trial questions or no?
No, no, because you were tied up in the hospital and stuff. So Joe helped me with.
No, I'm talking about recently. Did I give you and develop trial questions?
No, you just helped me, with what I needed to file in an emergency the other day on Wednesday.
Okay. Do you have do you have all of the witnesses and their names that the state is calling forward? The witness list?
Yeah. All the police officers that were there, basically.
Do you have the witness list?
Yeah. Let me see if I can find that too.
Because if you have that, whether it's scanned in or not, you could just take a picture to it and send it to me.
Okay.
Yeah, if they gave you that, because I think in one of the hearings I heard them say that they just gave that to you personally. But if you take a picture of it, that'll work as well. Because what I wanted to start doing is at least set up all the trial cross examinations questions, right? And then get. Are you going to be getting? Well, you said you're probably going to get a public defender, right?
Yeah, I filled out the financial declaration. So yeah, we're not going to have trial on Monday at this point. We're going to hopefully, I don't got too much money to
get a private,
be able to get a public defense attorney at this point.
Okay.
I had to put in how much money I have and this and that,
and let's see
what I got in investments and blah blah blah, just to see if I can get a public defense attorney, which I'm pretty sure I can. I've got proposed instructions from the plaintiff's proposed instructions to the jury here.
Where'd you get that at? Because
they sent that to me. I can't find their motion of limine that they sent to me.
Jury trial readiness master, for dire question bank and juror challenge strategy, proposed jury instructions, opening statement and closing argument script, cross examination scripts too. The single most important moment at trial. When Brett cross-examines Deputy Gates, the entire case turns on this question. Deputy Gates, you have no evidence whatsoever that I was engaged in commercial activity on December 29, 2055, do you? If the answer is no, the state's jurisdictional basis collapses. The jury will hear it, the record will reflect it, and the closing argument writes itself, it says.
Right.
Then we have a jury trial, but I mean, you don't, but maybe the what you call it will.
Yeah, I might worry myself about these dang jury trials. The jury's going to look at that if they're just regular people and be like, I have to get a license. Why doesn't he? Type thing. I mean, what's your thought on that? Every time I hear it, it makes me nervous.
The state is attempting to criminalize the exercise of a fundamental creator-endowed right, the right to travel, by labeling it a commercial privilege and then revoking that privilege. The state's own statutes, including RCW 47.04.01013 and Pierce County Code Section 104.04.010N, define the roads as open as a matter of right to public vehicular travel. You cannot suspend a right. I mean, that's really how you lay it out to the jury. And of course, their comprehension is going to be not so, but I mean, you've laid it out. You know what I'm saying?
Well, I was put all, just like Carl Miller said, and on those 3 different Supreme Court cases, I was going to lay it right out to the jury just like that. And it's like, I know damn well some of them would agree with me because, hey, it's already upheld in the Supreme Court, man.
I would say something.
I'll be like, you know, we were all duped into making us believe we had to get a driver's license, and it's all fraudulent. So once I found out we have the right to travel, man, I'm tired of getting taxed on all my vehicles every year. Now I don't have to. Oh yeah, you would do the same thing if you didn't have to pay for tabs every year ever again. You'd do the same thing. Oh man, I know I could win this. I know I could win this, but man, I ain't never done no trial before. I'm going to see how it goes first before I do a trial on my own, I think, at this point.
Understandable. What I would say, too, though, is you have a voir dire jury selection strategy governing rule. Voir dire in Washington District Court is governed by CRRLJ 6.4. The judge initiates voir dire, but the parties have the right to ask follow-up questions. Brett should request the right to conduct his own voir dire examination. How to request voir dire participation. Script. Your Honor, pursuant to CRRLJ 6.4, I respectfully request the opportunity to conduct a brief voir dire examination of the prospective jurors to determine whether any juror harbors bias that would prevent them from fairly applying the law as instructed by this court. The three jury profiles to eliminate. Profile. The defense juror believes identifying characteristics would be that they believe police officers are inherently more credible, has law enforcement family members, says if you weren't doing anything wrong, you wouldn't have been pulled over. The challenge type, challenge for cause or peremptory. Then the anti-pro se juror expresses skepticism that a non-lawyer can present a valid defense, seems annoyed that Brett is representing himself, challenge for cause or peremptory. And then the regulatory deference juror works in government administration, DMV, or licensing, believes all government regulations are valid and must be obeyed. That's a peremptory challenge. And then the libertarian expresses skepticism of government overreach, values individual rights, self-employed or small business owner will be receptive to right to travel argument. Why keep? The burden of proof purist emphasizes that the state must prove its case, has served on a jury before, and understands reasonable doubt, will hold the state to its burden. And the independent thinker does not defer to authority automatically, asks questions, seems curious about the case, will engage with constitutional arguments. Number of peremptory challenges. Under CRRLJ 6.4e, each party in a district court criminal trial is entitled to 3 peremptory challenges. Use them strategically. Save at least one for the final round of selection. See, so this kind of like some shit like, bro, boiling up. You know what I'm saying? Like, you got these rights that you need to invoke on getting this brief, right, opportunity to an examination of the prospective jurors to determine whether any jurors harbors the bias and would prevent them from fairly applying the law as instructed by this court. And I think that's maybe these are some of the elements, right, that the judge is speaking of in relation to knowing how to handle the juror, or jury in relation to its selection, or elimination of said jurors in and of itself. So then, part 3 is jury instructions, strategically how to submit proposed instructions. So the script will be, Your Honor, pursuant to CRRLJ 6.15, I hereby submit my proposed jury instructions. I respectfully request that the court include proposed instruction number 4 regarding the definition of motor vehicle and the fundamental right to travel, as this instruction is directly supported by RCW 46.04.320 and RCW 47.040.01013, in controlling federal authority, including Robertson versus Department of Public Works and Kent versus Duels. The 5 proposed instructions and their strategic purpose. Number 1 is the presumption of innocence, WPIC 4.01. Strategic purposes that reminds the jury that Brett starts at not guilty. Number 2, credibility of police officers, WPIC 1.01, which eliminates the badge equals truth assumption. Number 3, instruction elements of DWLS, WPIC 93.02, forces state to prove all elements, including commercial use. Number 4, definition of motor vehicle, statutory plus constitution. The most powerful instruction creates the traveler versus driver distinction. And then number 5 is the rule of lenity, common law canon, requires ambiguous statutes to be read in Brett's favor. So if the court refuses proposed instruction number 4, you would state, Your Honor, I object to the court's refusal to give proposal instruction number 4. The failure to instruct the jury on the distinction between the fundamental right to travel and the commercial privilege to drive constitutes a denial of due process and a violation of my Sixth Amendment right to present a complete defense. I note my objection for the record pursuant to CRR LJ 8.6. Right? So then we're going to download this real quick because I want to look at the jury instructions. Oh, it's going to not download.
Hey, Kim, I found that motion of Lamine that the state sent to me on March 20th, so I just emailed it to you.
Okay, cool.
Yeah.
Okay, here's the proposed jury instructions. Come on, man, this is what you doing. Working heavy right now, huh? Let's see. I don't need that one. I need. Where's it at? I don't even see it. It's already tripping. Dang, my man, this is going slow. All right, let me look and see what you sent me.
It's cooking. I'll give it that. It's cooking.
Yeah, it's my own computer is going slow. I don't see it, Brett.
I think it's right there at the top.
Nah, ain't nothing new. That was at 10:41. Nope, this was yours.
Oh, I just sent it to you here. Let me see.
It ain't come through yet.
Okay.
Let me check over here. Okay, yeah, that's what I wanted. Briefing, appeal roadmap, verify procedure.
It's to your TONEAV.
Yeah, I got it. Hold on. I feel you. I just ain't got it yet. Hold on. So we're doing proposed jury instructions. Let's see what this is looking like. I want to make sure to go through everything so that people are aware of just what's going on. So let's see. We're doing Brett proposed jury instructions. Let's see what we got cooked up. Select all, delete. Boom, boom, boom. Okay. Proposed presumption of innocence, burden of proof. Okay, proposed credibility of witnesses and police officers. Based on WPIC 102, modified for equal dignity, you're the sole judges of the credibility of each witness. You are also sole judges of the value or the weight to be given to the testimony. In considering the witness's testimony, you consider these things: the opportunity of the witness to observe and know the things they testify about, the ability of the witness to observe accurately the quality of the witness's memory while testifying. You are instructed that the testimony of law enforcement officer is not entitled to any special or greater weight simply because of the officer's position or uniform. You must evaluate a police officer's testimony by the exact same standards you would use to evaluate the testimony of any other witness. Proposed instruction elements of driving while license suspended. Based on WPIC, are modified to reflect statutory definitions. To convict the defendant of the crime of driving while license suspended or revoked in the third degree, each of the following elements of the crime must be proved beyond a reasonable doubt. Okay. Proposed instruction, definition of motor vehicle and driving. Proposed instruction number 5, rule of lenity. So it's giving you those right there. So these are proposed jury instructions, which I wonder what the attorney would do. But we're going to put these in proposed jury instructions dash paste, and take that out. Let's see what else we got. Remove Brett. Okay, so we got motion in limine, which you don't need. You could throw in a counter to their, but that's going to be something that the judge or your new attorney would do if you did it. Jury readiness, verify procedure research, public defender. Let me see. So we got, if you're bringing in the public defender, briefing, appeal, attorney action checklist. Four most important things the public defender must know. The CRLJ 8.2 structural error is the most powerful appellate issue. The district court denied the motion to suppress without written findings of facts or conclusions at law. Structural error. On RALJ appeal, the Superior Court reviews errors of law de novo, meaning it gives zero deference to the district court. The attorney must preserve this error on the record at the start of the trial with the exact words provided in the briefing. The 30-day RALJ deadline is absolute. The notice of appeal must be filed within 30 days. Entry of the written judgment. If this deadline is missed, the right to appeal is forfeited. The attorney must file the notice of appeal and the motion for stay enforcement on the same day the judgment is entered, or no later than the next business day. The right to travel deference is grounded in Washington's own statutes. Yep, right. And the state never rebutted the affidavit. The complete appeal timeline. 30 days from judgment, discretionary review, discretionary, the entire case, 30. Okay, so let's see the briefing. It doesn't give, why does it only give a MD option? Oh, it is in PDF, my bad. Brett, public defender, master guide. Then come back over. So let's say comprehensive public defender briefing. The briefing constitutes formal transfer. Appointed cancels not okay. So the case factual. This is everything you would brief them on. Wait a second. So they're charging you with driving while license suspended and no valid operator's license?
No, they're just charging me with driving while license suspended and
resisting,
driving without ignition interlock. They're charging me with obstructing and resisting.
So an obstruction and resisting. I wonder why you only have 2 case numbers, though. That is true. Okay. Ultravirus, DOL suspension, reversible errors, pretextual stop, which she denied, 6th Amendment Bill of Particulars, sovereign citizen label, the appellate roadmap, governing review, habeas corpus. Okay, so you got that one. The appeal, attorney, client briefing, attorney checklist. Yeah, bro, if you're going with one, I mean, that's going to be right before, right? Damn, this
What's
is
that?
crazy. Just right before. She said if y'all, if you're going to do it, then you got to let her know right before, and you still have that right. So, I mean, they're
Oh,
going to
I
have.
already let them know yesterday. I filled out the financial declaration form for a public defense attorney. So,
Oh, so they already know?
yeah, they know. So they already called off the jurors. They already called off the cops, witnesses, and shit. So, but I still got to go in there on Monday morning, though.
Stage trial for. Yeah, they're going to assign you a public defender then on Monday. So these are your
Right.
charges. Here are the 4 charges. Failure to have an ignition interlock, which they failed to even. Y'all failed to even go over that DOL then, essentially, is what. Y'all never went over that. You filed that, correct?
Oh well, yeah, that was in one of the motions, part of that and shit, and
Let me.
which it doesn't even apply to me.
Okay, so you put in a motion to challenge the DOL error, and she never did. Okay, let me ask you.
Oh no, because you I didn't put that in because remember, and then I got the prosecutor's response after I was going to file that, and then me and you I filed the memorandum in support of the right to travel, and I filed a response, so I didn't file that one.
Yeah, this one you were supposed to file with the exhibit, which we went over, which gave the judge's handwriting. You remember? But you never filed that, huh?
There's a couple things that I was going to file, but then all of a sudden I got a response from the prosecutor, so I booked another hour with you the next day, and then we put together a couple other things to file and not file those.
Yeah, because something that was interesting is that you were supposed to have an interlock for just 1 year. The judge wrote it on the document, right? On all
Right.
of the orders. And then the Department of Licensing issued out a 5-year period.
Right.
Correct. Okay, good. So they made that mistake, but you never entered that information, which would be this motion with those exhibits, into the record, correct?
Right.
Okay, so that's going to be something that you need to bring up with
I mean, I put
attorney
it,
as well.
Yeah, I put it on the record. As exhibits. Yeah, the sentencing, from the previous DUI and shit.
You put
So
it
they
in where?
know
Under what? Under what though? How'd you bring it into the record?
it's one of the exhibits on one of the motions I filed in the past. Yeah, we put that, and so that's all on the record that I only was supposed to have it for 1 year.
Okay. You need to brief him on that.
Oh, absolutely, yeah.
Okay, they're giving you your witnesses too. 1, 2, 3, 4, 5, 6. Miller Gates is his name. Miller Gates? That's his first name? That's crazy.
When the statutory law was, if you've never had an ignition interlock for a whole year before, because back in 2007, when I got my first DUI back in my 20s, I only had it for 6 months and 2 weeks. You know what I mean? And so that's why me and my attorney back in 24, we had the judge write that on the paperwork because, supposed to have it for just 1 year with no priors. It's basically like my first offense, but the fucking Department of Licensing, they want my money. They're like, no, you got to have it for 5 years. And I had it for 2 years. And then I found out about the right to travel. I'm like, yeah, fuck these motherfuckers. I'm sick of paying $361 a month for ignition interlock and SR22 insurance. And then, I ride my motorcycle all summer. So now I'm facing up to a year in jail and a $5,000 fine if I get caught riding my motorcycle because they don't even put an ignition interlock on motorcycles here in Washington. So that's why I did this for the right to travel because I had that. I had it for 2 years in my car, but I was scared to ride my motorcycle. And I'll be damned if I go 5 years without riding my motorcycle, dude. Fuck these motherfuckers.
Well, if you revive, if you fuck,
Amen.
If you surrendered your license, bro, they can't hit you for driving while license suspended anymore.
But yeah, for sure.
That's not applicable. The only thing that they can hit you for is no valid operator's license if they want to. It's the
Yeah,
same situation. It's the same situation that I've just been applied in, right? I got
yeah,
pulled over on my bike by Yakima. He first came out and was talking about, I'm giving you driving my license. And I said, you can't do that. I don't have no license. You need to check in there and make sure that I have a license because I promise you that's why I don't have no picture in there. And he goes, all right, you're right. So then he takes another 15 minutes to get rid of all that information and give me a driving or giving me a no operator's license or no driver's license, right? So then I get pulled over by motherfucking me, who is it? Union Gap, but that's where Sergeant Gates was reviewing everything. And this guy gives me a driving while license suspended ticket, right? So you see, like they be applying it differently. One
yeah.
actually applies it right because I don't have a driver's license, which is just a Class C, which is an infraction, which I don't even show up to court on because I have no contract with them. So they can establish whatever they want because all they're going to do is issue out a, hey, you need to pay us, and then they're going to put it in the collection somewhere, which then never is going to pursue me, which is never going to be on my record. This is going to sit in their office somewhere as a claim that they want to get money out of me. But then, doing a driving while license suspended, well, that gets bumped up to a higher misdemeanor. You see what I'm saying? But it's not applicable because I don't have a driver's license anyways. So you can't
Right.
give me a driving while license suspended because I don't even have a license in the first place.
Exactly.
So that's what I'm saying. You can put in, if you surrendered your license and then they apply the driving while license suspended, that would be non-applicable. It's unconstitutional. It'd be unconstitutionally applied.
Right.
So they put in a motion to limine here, which I'm gonna have get granted or have a response at least developed. That way you can have something to provide to. Yeah, they have it in the third degree. Obstructing a law enforcement officer and then resisting arrest. You didn't resist arrest because your seatbelt was buckled. And they even stated it.
Yeah, and I mean, they tried to say that, oh, I was trying to like stop them from pulling me out of the car because my leg got caught in the steering wheel briefly. Well, dude, I'm 6'7" in a little Toyota Echo. My leg got caught briefly while they were trying to yank me out of the car. I didn't do it on purpose. Like I wasn't obstructing anything.
Did they provide you with the body cam of the person actually grabbing and taking you out of the vehicle?
That's the only body cam I got that you've seen of them pulling me out of the car. So
Was
you can't
Gates?
even see my leg or anything. I'm gonna go review this footage. I'm gonna review all the footage tomorrow. Actually, when I get home, I got the copies of it. But I mean, yeah.
Okay. Let me see. We're busting over to. Let's see what we got over here. Anything yet? Yeah, because you got 5 different officers to cross-examine. A lot of them is not going to get much questioning. It's just really going to be questioning of, I would think, Gates mostly. Yeah, and then the guy that
probably the
broke.
sergeant.
Yeah, the one who broke the window.
Yeah.
And then I would come in and maybe some of the quotes that was made in relation to when they were in the car and kind of making fun of you, when you were speaking very clearly, they were making fun of you while you was in the back of the cop car and you was just trying to explain it, but
Yeah, and then I said, I can't wait to sue you motherfuckers. Oh shit.
just to let y'all know here, when he says an Echo, that boy was in a small ass car, and my boy is 6'7". So just so y'all are aware, this is the Echo. Okay, and yeah, it's a pretty small car. I can see how you'd get caught up being 6'7", bro.
Yeah. I wasn't purposely trying to stop them from pulling me out, dude. My leg got caught on the steering wheel just for like a second. It's like they're trying to get me for obstructing. Fuck them motherfuckers, man. I'm the victim here. Fuck them.
6'3" in a Fiat. Wish you could have seen it. Seat laid back, no cap.
Well, you got to make sure that with your public defender, when he comes through, that he makes sure that he is making sure to go through all of the elements, right? So each element of RCW 46. Let's see what we got on here. Well, I don't need to do this one yet. Let's do this one first. We'll do the obstruction first. So we'll copy, we'll check the elements of it. Okay, obstructing a law enforcement officer. A person is guilty of obstructing a law enforcement officer if the person willfully hinders, delays, or obstructs any law enforcement officer in the discharge of his or her official duties, powers, or duties. Well, what powers or duties? What duty were they doing? The official powers and duties. Man, that helicopter is very low. What duties? What was their duty? This is very vague, bro.
Right. Well, their
This
duty
is
is
very
supposed
vague.
to be to uphold my rights instead of just fucking breaking my window out just because I didn't get my ID. What was that thing you just put on there the other day? I seen you on YouTube or something about, not IDing when pulled over, not IDing or something. I remember seeing that. I want to print that off.
That's Browns versus Texas.
Oh.
No, it was something else. I even took a screenshot
Man,
of it.
it's Brown versus Texas, bro.
Uh-huh. Yeah.
Okay. It's Brown versus Texas. Okay. The application of a code or statute to detain an appellant and require him to identify himself violated the Fourth Amendment because the officers lacked any reasonable suspicion to believe that the appellant was engaged or had engaged in criminal conduct. Accordingly, appellant may not be punished for refusing to identify himself, and the conviction is reversed. Browns versus Texas. Why is that? It's because traffic infractions are not a crime. People versus battle. To this end, the Fourth Amendment requires that the seizure must be based on a specific objective facts indicating that society's legitimate interest require the seizure of the particular individual, or that the seizure must be carried out pursuant to the plan embodying explicit neutral limitations on the conduct of individual officers.
Yeah, the one that I seen you were doing something. It's like Collender versus Lawson in 1983. You did a little thing on it.
Oh no.
Oh, and then it also says C Brown versus Texas also.
Yeah. Brown
versus
Texas. Yeah.
And the state is named the party.
Yeah.
And it's biased in itself, is it not?
I'm tripped out that she ain't giving no written determination up front though. That's kind of like you're supposed to be getting that for real. Okay, so let's see what we got over here. It's claiming omnibus objections to state's motion in limine and counter motion. This one's just the basic layout. Let me see if I can get the latex complete. Part 1. Do y'all got it completed? Okay, there it goes. Download. There's an analysis on it too. Let me see, copy. This is going to be a response to their motion in limine, since you already filed one. Make a copy. Right. Paste. Dang, I gotta go to the restroom real quick. Let's see.
I got you, Brandon. Look, that's from the laws you didn't, exist, right, Cam?
Yeah, I can send it. Y'all want it? Is someone wanting it? I'll throw it in the chat right now.
You probably have a better one than me. I'd like to get the one you have.
Here, I'm throwing it in the chat right now, y'all. There y'all go. There you go. Who asked for it? Brandon? Yeah, there you go, Brandon. I threw it in the chat, bro. You just can download it. All right, let's see. All right, the defendant's omnibus response and objections to the state's motions in limine and counter motions in limine. I'll give you this, Brett, so that you have it for the public defender and yourself.
Are you putting it in my channel then?
Yeah.
Okay, thank you so much.
I'm gonna hit him with another one, Cam. Okay. Laws you didn't know exist.
Yeah, 101. We actually need to go through that. There's a lot of stuff I need to go through in that, and we haven't yet. Okay, let's check out this response. See what we got. All right, procedural factual disputes. What is this? Defendant's claim. It comes now. State's represents a systematic unconstitutional attempt to sanitize the record, suppress the defendant's fundamental creator endowed rights, and strip the jury of its constitutional function. Through the 17 separate motions, the state seeks to prevent the defendant from arguing the law, explaining the burden of proof, challenging the court's jurisdiction, and presenting the very constitutional defendants that form the core of this case. The state's motions are not evidentiary gatekeeping. They are prior restraint on speech and structural violations. The state's relevant facts, Section 3, contains material representations of law and fact that must be corrected for the record. So this is, again, you can't allow them to accept this shit. Like if they're bringing in this motions in limine, right? Man, I got to go to the restroom. Y'all talk amongst yourself for a second, okay? I got to go to the bathroom.
Okay.
Anyways, way to go, Brett. You showed no fear. Talk fast. That was good.
Yeah, I mean,
you always have remedy because there's obvious denial, due process, and bias.
Right.
Just don't know at what point do you file into the federal with all this evidence. I think it's after conviction.
Yeah, you got to wait till after, if they do convict me. Well, hopefully they don't, but you know, I might get convicted on something. Who knows?
Dude, don't you have the right? Doesn't he have the right to just go in and be like, dude, there's an emergency going on right now, and I'm going to suffer irreparable harm if this court doesn't intervene? For an official appeal, maybe you have to wait till after, but as it relates to danger and irreparable harm against an American being voir-dired by this court, fuck that. You should be able to go in for a stay tomorrow.
I would let the violation continue, and then you have crimes on the record against them.
Well, I get that too. That's actually a good strategy. But all I know is, bro, I forgot your name, but the other guy who did the standing, what's your name again? Brett or something? Or
Brett.
Yeah, that's me.
You freaking killed it, dude. You said the things like 3 or 4 separate times. I'm surprised the judge didn't just say, let's dismiss this in the interest of justice. No. She showed her colors of being on the side of the state and having a prejudice against you. They're trying to keep it in the state.
Yeah, she's biased. She's getting paid by the state, man. She's biased. You know, that's what Tanawa Downing's trying to do all this for.
All they have is want. They just keep showing their want, but for want of jurisdiction. They just want. The only thing I could have thought of is when you said I appear here specially, and that judge was like, well, we're moving on to this and that, was for, you could have possibly said, Judge, I can't hear you. I can't hear you. I've just filed my special appearance. That's in challenge to this jurisdiction. We can't move forward until that's met.
I mean, I did that the first couple of hearings for sure. I've already challenged it numerous times, man, and they think I got.
Did you try the I can't hear you little tactic? It's
no,
like I can't hear you.
It.
Well, I'm just saying it out loud now. I can't hear you, Judge. I have a special appearance, and you're trying to move forward. I can't hear you, and just sort of stay there. I can't hear you.
Okay,
I don't know
if
it's just a thought. You have to judge yourself at the time, but.
Hey, but what I just filed, I filed that Nisi Prius document. You guys know about that?
What's Nisi Prius again?
The process.
I forgot.
Oh, man, you should go read it. It's badass, right? For a Nisi Prius court, they got to prove all these things on the record, right? And they didn't prove, the prosecutor didn't prove shit. She barely even get a response. And then
so Nisi Prius means their court is the colorable court.
That's right. And, you know, and I also filed all my state national documents that I already filed on the record with Pierce County Recorder's District. I got them all in on my channel, all my documents. I took pictures of them. You should check them out. And the prosecutor's like, oh, well, we don't even want to have any of that. It'll confuse the jury. Right. See, because I'm a state citizen, I'm a state national, so I have my fucking right to travel, dude. That's why I spent $361 to fucking file those documents with Pierce County Recorder's District office. It's been on the record,
baby.
Huh?
Yep. State citizens, it's the way to go. Make sure you're hanging that peace flag. Fly that peace flag, bud.
Yeah, I mean, I filed that back in July 2nd of 24, right after I went ahead and surrendered my license and decided to do all this. And I got a 5-star, and I got a 5-star national passport too.
We're basically taking the cookie away from the fat kid.
Wait a second, you got 5 stars on your passport? I only have 3.
I got 5, bro.
Copper
Motherfucker, why did
Moonshine
they?
Stills. Go check it out.
I gotta
I'm
call them
waiting on my
and
birth
file again or something. There's got to be a process for
Look at
update.
those five stars right there. 5.
Hang on. Oh my dear Lord.
Copper Moonshine Stills.
Has anyone ever
fuck
figured
at
out
that.
what the relevance of those stars are?
Well, the Bad Wolf, he called them, and the guy that he had contacted him a long time ago, he actually called the government, and it's basically like a security thing. They didn't tell him really anything, but what they found out is like 1 and 2 star, for some reason you might be watched. 3 stars is you're kind of 4 stars, you're a lot better. 5 stars should be a do not stop, do not detain.
Right.
I've heard his take on that. I just wonder if we actually
You
found a source from the government that lays it out.
No, they kind of keep that secret.
They don't want this information out there, man. It's all about revenue, man. They're just trying to fucking put me right through their system, get a conviction, fucking fine the shit out of me. I mean, I looked it up how much the fucking charges were, and it's like $1,500 for the driving while I suspended without ignition interlock also, and it was obstructing and without and resisting is another $1,500. So they're gonna try to get me for at least $3 grand in fines and put me in fucking jail.
How long?
Keep that stuff out of your head. Keep the negativity
How long
out of your
for?
head.
Right.
How long is the sentencing?
Huh?
How long would be the sentencing?
It could be, I don't know. I'm facing up to a fucking year, dude. It's they're all misdemeanors, but couple of the charges are up to 90 days, and another one, I don't know. I'd have to look into it.
They need to if you're getting charged a year and a day, they need a grand jury indictment.
Yeah, I don't think it's. I don't
Even
think they
though
charge me
Washington,
over a year.
even though Washington State Constitution says, no, jury will be summoned in this state or any county, but still, they have to follow the federal Constitution under Article 1, Article 5, Section 1.
Okay. Yeah, but I'm gonna beat these fucking charges, and if I don't, I'm gonna beat them on appeal.
Right. And also, there's a Rule 60b-4. A court acting without jurisdiction, the judgment is void.
Exactly, and they don't have jurisdiction over me, especially when I'm a state national.
They don't have subject matter, and they don't have personal jurisdiction.
Exactly.
And they have to prove it on the record, and they haven't.
They haven't. I don't even know how they can fucking put it all the way to trial yet. They haven't proven it.
Doug, since when do they give a shit about that?
I know, right? Don't. All they teach them is statute. They don't teach them Constitution. At their peril.
Yeah. Exactly, because the fucking judge and the prosecutor, they're on the chopping block too, bro. I promise you. I'll sue all these motherfuckers.
Mm-hmm. In their personal capacity. They don't take from the people.
Right. Right. Oh yeah, I wonder how much they had to spend to pay these officers to come and be witnesses and to pay the jurors. I think the jurors only get paid like 25 or 35 a day, but they got to pay the officers their full wages, I believe.
And they got insurance, don't they? You can go attack the insurance.
Yeah. See, I don't know how to do all that, man. I'm learning, man. I'm learning, I tell you.
Okay, let me see if I go back to share. Share.
Nice close up, Cam.
Let's see. Show. All right.
What a beautiful man.
Defendants, claimants, omnibus, response and objections to states, motions in limine. Is that in there? Okay, yeah, it's in there. So I'm sure he needs to have something like this presented. You know what I'm saying? I would run through this. If you're going to have a public defender, then of course you're going to have to brief him and go through everything, but things should be in great detail as far as a response to their motion in limine for yours as well. Yours as well. You should have a response to object a lot of the things that they are saying because you don't want to accept it.
Right.
And you have to have a rebuttal on the record, or they're just going to get all their shit granted because, as you can see, through everything that they're asking, it's a granted, denied, reserved, or agreed, right?
Right.
So for all of these, which I think there's like 17 of them, you're going to want to have that public defender rebut those bitches and not just accept them. Or
Absolutely.
they probably will get the state's exclusion, agree with modification. So you'd agree with number 1. You'd strongly oppose number 2. You'd partially agree with number 3. Missing witness, you would oppose correct entirely. The jury nullification, you would oppose. The state conflates legitimate constitutional defenses with jury nullification. The defendant claimant does not intend to ask the jury or ignore the law. Rather, the defendant claimant intends to argue that the law properly applied to a sovereign individual exercising his creator endowed right to travel requires acquittal. The state's reliance on State versus Mingsley is misplaced, as that case involved a requested instruction to nullify, not a restriction on closing argument regarding the failure to state's proof. Speaking objections, you would agree with reservation. Number 7, the procedural history you would strongly oppose. Why would you oppose it? The state seeks to sanitize the record and hide its own procedural defaults from the jury. The state's failure to respond to the defendant's claimant's sworn affidavit of truth constitutes an admissible admission by silence under the maxim of quite tacit. I'm not even going to read that one. The state's failure to adequately answer the Bill of Particulars is a violation of the Sixth Amendment and the right to be informed of the nature and cause of the accusation. These procedural facts are directly relevant to the state's failure to establish jurisdiction and its failure to meet its burden of proof. The jury duty response would be to oppose. The state seeks to prevent the defendant claimant from reminding the jury of its solemn duty to acquit if the state fails to prove its case beyond a reasonable doubt. The jury's duty is not merely to decide the facts. Its duty is to protect the individual against the overreach of the state. Jury instruction number 9, strongly oppose. This is the state's most constitutionally offensive motion. The state seeks to prevent the defendant claimant from arguing that the state has failed to prove the jurisdictional elements of the offenses. While subject matter jurisdiction is a question of law, the state's burden to prove the defendant claimant falls within the statutory definitions. Driver, motor vehicle, encumbrance, excuse me, is a question of the fact for the jury. The state's reliance on State versus Oakley is misleading. Oakley holds that the court determines its own power to hear a case, but it does not relieve the state of proving the factual predicates of its regulatory authority to the jury. Furthermore, the court's prior or denial of the jurisdictional challenge without written findings is legally insufficient and not a final order. Witness credibility, you would agree with modification. Undisclosed evidence, agree with reciprocity. Video camera footage, you would oppose with conditions. Certified driving record, you would strongly oppose. The state seeks to admit the Department of Licensing record without live testimony, violating the Confrontation Clause of the Sixth Amendment. While State versus Kirkpatrick held that routine DOL certifications are non-testimonial, the record in this case is not a routine certification of existent and contains substantive contested legal conclusions, specifically that a valid suspicion existed and that the interlocking device requirement was lawfully imposed. Because the defendant claimant challenges the underlying administrative acts as ultravirus and void ab initio, the DOL record functions as a substantive testimony against him. Under Melendez-Diaz versus Massachusetts, such records are testimonial. The state must produce the DOL custodian for cross-examination regarding the basis, accuracy, and administrative procedure underlying purported suspension. The QA format, you would oppose. The impairment, you would impose. Intern Rule 9 reference, you would agree the defendant claimant has no intention of referencing the prosecutor's intern status. And pro se instruction, you would strongly oppose. States, trial conduct, no conflicting law, you strongly oppose. No uncovered law, strongly oppose. And then you would counter, these are your counter motions in limine. The exclusion of sovereign citizen label, the exclusion of post-stop discovered evidence. The state must be prohibited from introducing any evidence discovered after the initial traffic stop, including the DOL record, the lack of interlock device, and the defendant's Defendant's refusal to identify himself and justify the initial seizure. The constitutionality of the Terry stop is judged solely by the facts known to the officer in the moment of the seize occurred. Because the private plate does not constitute a traffic infraction, all subsequent evidence is fruit of the poisonous tree. Then you do a counter motion exclusion of unsworn police narratives. Yeah, and then your conclusion. Then the proposed. Denied, and then granted. Certificate of service as well. Yeah, I think I threw that.
I'm liking the counter motion. Go on the offense.
Yeah, you have to counter their shit for real. Let me see what else I got. Research.
Oh, hey Cam, I just emailed you what the state's supplemental motion of the mean. They just sent me an email yesterday or the day before, but it's all about to allow the state's law enforcement witnesses to testify the defendant's pre and post Miranda statements, blah, blah, blah. I just emailed you what they sent me. It's a state supplemental motion in Lamine, I guess. I just emailed it to you.
All right, I gotta wait for it to come in. It ain't come in yet. Let me see. Boom. Back over here. Research notes, response to state's critical findings. Confrontation clause, primary argument, the DO record in this case is not merely a routine certification of public record, it's a substantial assertion. Obstruction, resisting key research. Willfully hinders key defense. The officer must be acting lawfully. If the initial stop was unlawful, pretextual, no RAS, then the officer was not in the discharge of lawful duties. Brett's refusal to comply with an unlawful stop cannot constitute obstruction. Case law that supports this: State versus Holman in 1985. Obstruction requires that the officer be acting in the discharge of lawful duties. State versus EJJ 2015. A person may lawfully resist an unlawful arrest. The resisting arrest, the elements: intentionally. Key defense, the word lawfully in this statute. If the arrest was unlawful, no probable cause based on an unconstitutional stop, then resisting is not a crime. Fifth Amendment right to refuse identification. The Supreme Court upheld Nevada stop and identify statute, but only because Nevada had a specific statute requiring identification. Washington does not have a stop and identify statute. Therefore, Brett had no legal obligation to identify himself. Washington law on identification, RCW 46.61.021, requires a driver to provide identification upon demand. But Brett's position is that he was not a driver under Title 46. If he was not a driver, RCW 46.61.021 does not apply, and he had no obligation to identify himself. Why are we speaking in this manner? Well, let's check real quick.
It's the fact.
Let's check something else real quick, y'all.
Someone please tell me how a state can pass a lawful statute saying we can stop and ID you like you are a stop and ID state. Hey, ID yourself. They can't, can they?
No, because Article 6, Clause 2, 4th Amendment, 5th Amendment.
Yeah, it's
Sixth
obvious.
Amendment.
This is a stop and ID state. This is a go fuck yourself state in that way.
So we're looking at the American Association of Motor Vehicle Administrators. This is a private organization. Okay, this private organization is what establishes all of the DMVs to act out what they act out. If you look on YouTube, you can search AAMVA, and you'll notice that they have a whole bunch of conferences where they actually bring in sheriffs and leaders and chiefs, and they actually discuss this and give awards for the agencies that have given the most tickets and done criminal activities, right? So this is their official use only, okay? It's their code dictionary and manual, all right? So this is what they're establishing out to bring forth to all of the other agencies. Okay, so if we come down to page, I think it's like 22.
I just grabbed it. That's all it was. Really? Yeah.
If we come down to page 22 within this code dictionary of the AAMVA, which is oversees and kind of establishes all of the DMVs, we have a note right here, and it says driving, okay, which would also include by context drive or driver, is now defined in the federal regulations as, quote, operating a commercial motor vehicle. Okay, so if I take this term right here, and I come over and I say, okay, I'm going to select this sentence because they have put it in quotes. we're going to now come over and say, okay, well, they say federal regulations is defining it as driving a commercial motor vehicle. Well, let's say we come over to Google Scholar. Okay, and we come into Scholar. I don't know if y'all have ever used Google Scholar, but it goes into articles and case law. Okay, and you can do federal courts. We select federal courts here. We admit Lodo again. And then we'll paste. We need to do it in quotations. So if you're bringing in a quotation and you need to search just that quotation, you put in the quotations on each one, search. We end up finding that this quote actually comes from Smith versus Old Dominion Freight Line. Okay. And then we do a find, paste. Doesn't want to search it like that. So let's do it like search like this. No, it's fine.
I hate to interrupt, but what was that last website that you went to because my Wi-Fi froze up on me?
Google Scholar.
Google Scholar.
Yep.
No, the one that had the codes AW.
Oh no, let me provide that to you on the chat. Let me provide that to you on the chat. The AAMVA. Okay, this is what is a private organization. It's non-governmental, but they establish all of the rules to the DMV. Okay, literally everything. That's literally what they do. That's their job. But as we see in the AAMVA, like I just showed y'all, right? This official use only. This is their code dictionary. This is what's established to everybody. Driving is now defined in the federal regulations as operating a commercial motor vehicle. You see, they put this in quotations. Come over here into Google Scholar. They pulled that case from this case right here. Definition: for the purposes of this section only, driving means operating a commercial motor vehicle with the motor running, including while temporarily stationary because of traffic. Again, this is coming out of Amy C. Smith versus Old Dominion Freight Line. I'll throw this one in as well because this is supporting. So these are things that you can utilize to support what you know and what you bring forth, right? Because, you know, these are your arguments. It's like, well, this is what I'm understanding. And that's why, you know, you need a written determination and order coming from these people because of, especially the courts, because if they're not bringing forth a written determination based on yours, you got to understand when they bring forth a written determination on the denial, you then have opportunity to submit what's a renewal, okay, or a reconsideration of what you've already brought forth, bringing forth their errors. And the reason I say that is because we did the same thing with Hayden, right? Once we got a answer back or a written determination from his judge, we came through and we said, well, you're gonna deny us on that. Well, we're just gonna bring forth a motion for a reconsideration of adverse rulings and a renewed motion to suppress evidence and dismiss all charges. And what did we end up doing? We end up coming through and the legal arguments included all of the court's errors, right? The court errs in its findings, y'all. Y'all think that every time that the court just brings forth the written determination that says, oh, well, we're going to utilize this case, we're going to utilize that case, that it's true and that it's, but no, we find the errors of the court and then we bring it forth on their errors and why the cases that they're utilizing or the determinations that they're bringing forth is erred or misapplied. It's just like, script. If I can get this to work.
And there's a bunch of errors in mine, I think.
Yeah, there would be a bunch. Of course, I would think there are a bunch of errors because nobody's even fucking answering. Truly. Okay, here's the file you shared with me. I see it now. Okay, so we got a state supplemental motion in limine. Oh God.
Because they didn't read my Miranda rights until they already arrested me and put me in the back of the cop car.
In my opinion, that's supposed to be done right as the stop happens.
So they're saying the step supplemental motion in limine to allow the state's law enforcement witnesses to testify to the defendant's pre and post Miranda statements. Well, when did they ever read you Miranda?
When I was in the back of the cop car and I told them, I said, I know my fucking rights, but that's when they read it to me.
Out of court admissions by a state, all the statements that seek to admit are relevant to the issues. They're trying to get everything off in there. I'm really surprised that she didn't give you a continuance, bro, based on your emergency motions too. It's very interesting. But yeah, once you get a formal written determination, that's when you would hit for the motion for a reconsideration and bring up all the errors.
Yeah.
But you got to get those written determinations. And she just was not. She was not giving them to you, which almost makes it seem like, you kind of went for a mandamus. The Superior Court didn't hit. You're trying to hit for the stay. You want to go to the District Court of Appeals for the mandamus to have them stay, but they didn't. She didn't stay it. So, but I don't know if you hit for the stay. Did you hit for a stay or no?
No.
No, yeah, we said it didn't hit for the stay.
No, Joe helped me put together an appeal and a stay of execution for when I was going to go to trial back in March, but I still have them.
My boy's going with the public defender. Man, you better hope that this dude really be on your shit, bro. Because if he starts opposing shit, it's going to be an issue. I mean, if he starts opposing what you need to get done, then that's going to be an issue that you really going to have to, bring home. Yeah,
if the public defender starts doing that, can you put the court in what is it? Not good faith. It's right opposite. I've heard somebody say it.
Inadequate defense.
Yeah, there's a way you can hold the court.
Stay research notes.
Not in good faith. That's what I was thinking about.
Let me see if I gave you your master briefing guide too. Yeah, you got a briefing guide as well. So yeah, when you meet up with this dude, y'all gonna have to really go through it and make sure that he does what he does. But listen, I'm not gonna say all public defenders are completely horrible because we now have two different situations. Ricky literally. I don't know if Ricky's still in here or not. Ricky, you still in here? Let me see if Ricky's still in here.
Yeah, I'm here, bro. I'm listening.
Okay, Ricky, tell us what happened with you, bro.
What up, everybody? I'm Ricky. I had picked up a case. Long story short, accidentally called the cops. They showed up crazy on high alert, banging the hell out of my door.
Yo, wait, Ricky. This one's actually a really good situation. I forgot his whole situation completely. And yeah, Ricky, explain it thoroughly, bro, because you actually got a lawsuit now that we got to pursue.
Watching the Ryan Garcia fight, I'm getting all excited. I'm clicking the SOS button, I guess, on the phone, and they showed up for a wellness check.
Ricky, show your face.
You want to see my face? Hold on, bro. Hold on.
Yeah, bro. I've worked with Ricky pretty heavily.
Let's see, how do I do this? I'm a rookie. Here we go. Oh, there I did it. All right. What's up, bro?
What's up, dude?
I'm over here with some people. I'm working.
Oh, I'm here?
I'm working, but I'm putting them on game too. I'm like, hey, y'all know what sovereign citizens are? So while I was watching the whole event, the police showed up and started banging on my door. And so I was like, quick, I need to get into cam mode. So I'm like, all right, identify yourselves. Why are y'all here? And they're like, we got a call from inside the house and nobody called you guys. So who am I speaking with? I said, I'm not helping you with your investigation. You're on my property. This is private property. You guys need to go. And they kept banging more. So I'm like, dang, let me get my phone. So by the time I grabbed my phone, I'm like, identify yourselves. Who are you? Name and badge number. Now they're getting real pushy and they don't want to. So they end up getting in their squad car and they start leaving. And I'm like, dang, these fools don't want to identify themselves. So I'm on the curb. I'm like, yo, this is them. They're leaving. They don't want to identify themselves. I'm still on my property, but I'm at my mailbox. And then they pull back around and now the dude gets off and I'm recording him in his face. And I'm like, bro, identify yourself. Who are you? Why are you here? What are you doing? And he grabs me and throws me to the ground. My legs go over my head. He flips me on my property. I'm like, bro, I'm just doing everything Cam said. Tell him I'm not your enemy. I'm not resisting. I'm not fighting you. And I wasn't. And they hauled me off, took me to jail. Never identified myself. Stayed quiet the whole time, even in there. Told them I'm not going to help them with their cooperation. Ended up posting bond and coming out. Contacted Cam real quick, told him the whole details of my situation, got on it, wrote up a quick script, sent it to me. I started studying it, and I'm not gonna lie, bro, I got cold feet. Y'all, I got real cold feet. I was about to go to court, and that was that time that you were sick, so I wasn't hearing no response. And then you finally wrote me back. I was like, oh man, I feel so bad. This dude's sick. I'm over here stressing. So I was like, you know what? Let me play it cool. Let me go tell my lawyer that I've been doing some research and this is exactly what he should do. And I did that, and the lawyer was like, that's not going to work. You should just take the plea deal. And they're offering you 6 months probation and a small fine. It's nothing, take it. And I'm like, bro, you're trying to make me work with the state. I don't want to work with the state. My rights were violated, bro. And he's like, well, I'm too old. Long story short, he told me I'm too old to fight this case for you. I can't do it.
That's crazy.
He went into the judge and dismissed himself. He said, Your Honor, we're not seeing eye to eye. He's asking me to do things that and I'm the lawyer. And she goes, all right, request granted. Some other dude came, and he said he's my new court-appointed attorney. So I said, look, these are the details. These are the facts. I have all my paperwork ready to go. The only thing you got to do is probably put your name on it because it's my name. I said, but this is a playbook that we drew up. And he looked it over thoroughly. He was actually very impressed. His eyes were like, doing that number.
Okay, cool. Wait. So when you met with him face to face?
Yeah,
you gave him the documents that we developed?
I have the documents in my hand in my what do you call it? My iPad. I don't hand them over to him, but I show him, look, go through this, step 1, step 2, step 3, step all the way to the contingency plan and everything. And he goes, if this is all it is, then this is a slam dunk. He's like, I'll get this dismissed. He's like, as long as there's no like spiders or something that you're not telling me that's going to come out and crawl and bite us in the ass. He goes, this is a solid playbook. Let's go. And look, my client's satisfied with this haircut. We're killing it in all areas of life right now.
So then you never had to go to court again? It was just completely dismissed?
Literally, like I called him back. I'm like, hey, we got court on Friday. He said, I'm sorry, Mr. Ramos, I haven't contacted you. I spoke with the clerk, the prosecutor that day, and the clerk from the judge, and they threw it out. They dismissed it.
Bro, lawsuit.
Yeah, that's what I told him. I was like, look, I honestly, I was on the fence. I was like, man, do I take it? Do I not take it? And I talked to a mentor. He said, look, son, if you don't take this, that guy's going to go back out there and he's going to do the same thing with someone else. And that's going to be irresponsible on your part because you know this. And I was like, nah, we gotta step up and do this. I'm with you, Cam. We got to set up that lawsuit.
Damn, bro. You got an easy lawsuit, dude.
Yeah.
You got an easy lawsuit. They just dismissed without no fight, bro.
Nothing. They rolled over straight up, man. They rolled over.
The only thing that I'm curious of is you still haven't been able to get any body camera footage.
Why?
You haven't, is what I'm saying, right?
Well, no, because I asked the lawyer and he goes, yeah, we're going to put motions in for this and that. But by the time, it was time to go back to court, he was like, yo, bro, it's done.
That means that the state reviewed it and they were like, yeah, we can't do this one.
Like that?
Dude, we got to put in a preservation of evidence ASAP.
Let's do it, bro. Send me whatever I got to do. I'm down.
Yeah, we got to put in a preservation of evidence ASAP, bro. Yeah, you're getting moved into civil cases, bro. So
let's go. That dude was trolling me online.
Wisedome.
Sheesh, bro.
Get that self-governing, bro.
Well, I need to. Damn, y'all have no video of the situation at all? Not your wife or anything?
I have the footage of me. I found the footage of me recording him in his face. And then I found a video of the neighbor's video where they're recording me go, yo, I'm not your enemy, bro. I'm not your enemy. I'm not going to help you with your investigation.
Okay, so what I'm going to do then is we're going to do a separate video together and review on your dismissal. All right. And what I need is those videos sent over to me so we can throw those into a video on YouTube so I can interview you. And then we'll push for, we'll just do a push that we're going to be bringing forth a complaint. So.
Oh, I'm down, bro. Let's set it up. Send me the play-by-play, and I'm on it. I'm with you.
All right, Papa. Nice. Congratulations. Everybody on mute until Ricky. Congratulations.
Yeah,
Congratulations, Ricky.
Congratulations.
Thank you so much, big dog. I appreciate all y'all. Thank you for the love and support.
Yeah, so for this one, as far as Operation Wisedome on the recorded version, we're going to be ending it on this one with a success at least. Hopefully, us thoroughly going through a lot of Brett's situation has given some insight on process and just, the denial of rights. And we can see that Brett stood up and made a record very clearly. He objected to a lot of things, and there's no doubt that we'll see probably a trial go through, but maybe we can see some success happening through a public defender. To say that public defenders can't do anything at all is not true. We're seeing that we do get some results through public defenders, so we might see maybe something come through with Brett's situation. But Brett, any final closing words before we close out today?
Man, I just want to say thank you so much for all your help, man. Seriously, from the bottom of my heart, man. Thank you, man. When you need my help moving, man, I got you, bro. Let's get it. Let's get it.
For sure. Everybody, y'all everybody just say good job to Brett, for standing up as much as he has, man. It's honest. Honestly.
Good job, Brett.
Brett,
Good job,
you
man.
you shoot him in another one.
All right, thank you guys. I appreciate it.
Way to go, Brett.
Yeah, for sure,
Thank
for
you.
sure. You standing up on it, and we can see a blanket denial, and it's not right. They know what they're supposed to be doing. There's a duty that's supposed to be given to you, and they just say, oh, well, you don't know the process. Well, I know enough of the process that you're supposed to be giving me what I'm asking for, and you denied me on it. So,
Exactly.
yeah, yeah, that's the end of this one. Everybody just say goodbye. I guess we out on this one.
All right. Later, y'all.
Deuces.
Y'all join Operation Wisedome.
You too.
Yeah, you dig. All right, we're going to stop.
Peace.